258-7590. Come on up to the podium. Your name? Who are you, ma'am?
I'm his mom.
What's your name?
Clarice.
Why didn't he show up on this? Do you know? He didn't tell you about it?
No, we didn't get the letter until really late. No, I don't know.
Well, this was issued back in May.
Yeah, I need it in paperwork where I never even.
The charge is that you failed to pay fines and costs in the amount of $213. You were handed the ticket on the 29th of May, right? You're not gonna grow up being this irresponsible, are you, young man? Because this is October. So that was 5 months ago. What'd you do? Throw it in a drawer?
No, I kind of like really forgot about it.
Forgot about it. Well, that's a good thing. You're getting issued citations. You're telling the judge you forgot about it. I'd like to forget to pay my mortgage. I'd like to forget to pay my insurance. Time to grow up. How old are you?
I'm 16.
Which school are you going to?
I'm good at one.
What grade are you in? How are you doing in school?
I'm doing really good.
How good's really good?
I'm doing like actually really good sports.
No. I didn't ask you about sports. Unless you're going pro, I don't care how you're doing in sports. I'm glad you're playing sports. It'll help keep you out of trouble. But only one out of about every 50,000 are going pro, right? So I'm asking you how your grades are.
Only have like one E, but the rest of the grades are really good.
What's really good mean? What's your grade point?
B's and C's.
Is that true, ma'am? Okay. Okay. Look, you can't be doing what you're doing. You can't ignore courts. You're being show caused as to why you shouldn't be sent to jail. Do you realize that?
Yes, sir.
And you were doing this at school too, right?
Yes.
What are you doing that for? You can't do that. Look, ma'am, I don't want to make the end of this, but I can't just let this go. I just can't let it go. So he's either going to have to pay this, or I might have to do something else. Now, if somebody can come up with some money here, I will strongly consider reducing the fines on these. I can give you a lawyer too. If you want a lawyer and you want a lawyer to represent you, that's fine. I'm going to be reasonable with you, but I'll be glad to give you a lawyer. Okay? But I don't like how your biggest concern I have is you didn't show up. That kind of tells me you're on the rock and along the lines of some of the people in this world now that think they don't have to respect authority. They usually end up on the losing end. You don't respect authority. I mean, there's a ton of them there. See it right on TV everywhere, and then we don't. So what do you want me to do? You want me to give them a lawyer? He's being show caused as to why he should be held in contempt of court because he didn't show up and pay, and we sent him letters. So the charge is failure to pay. He got the ticket May 29th. I'm not revisiting that. It was handed to him. He got a ticket on May the 29th, and he got a ticket on April the 23rd. So he just threw him in a drawer, and he thought he could come in and say to the judge, I forgot about it. He owes $213 on each case. So what do you want me to do? You want me to give him a lawyer? Can you pay some for him? I doubt he has the money. I'll cut it down. I'll be reasonable with you. But I'd like to get rid of this today. And the biggest thing is I want him to understand you just can't do this. Do you understand that?
Yes, sir.
My mail is locked behind it. We can't get it. So I got the mail. I only got this letter. I never got a ticket.
Well, they handed it to him. They gave it to him, right? They gave it you the tickets, right?
Yes.
Okay. Yeah, so he got the tickets and he just decided he was gonna throw them in a drawer or crumble them up and put them in a garbage can. I don't know what he was thinking. Where do you work? Do you have $100 today?
I could try to get $50. I get paid Friday, but I'm already in the mix sheet for it. I squeeze 50.
You see the predicament you put your mother in? Did you see this?
Yes, sir.
Is his father in his life?
Sees it out.
I'm sorry. You're paying more attention to your school.
Yes, sir. Definitely, yes, sir. Definitely, yes, sir.
Because if you don't graduate high school, right?
Yes, sir. My teachers already told me.
Yeah, because this world, like when Abraham Lincoln was alive, they didn't have high school diplomas as much. You follow me?
Yes, sir.
Now you gotta at least have a high school diploma or you're gonna be. All right, let me see what I'm gonna do here. What sport are you in?
Well, I'm university.
Ma'am, I'm gonna adjourn these show causes. I'm gonna give you some time to get some money together. You wanted me to do that? And I'm gonna be very reasonable. Okay? But young man, you gotta grow up, son.
Yes, sir.
Are you driving yet?
No, but, I'm about to get one permit pretty soon.
All right, so I'm just telling you, on its face, somebody who's throwing tickets in the garbage and not telling their mother, putting them in drawers and forgetting about them. That's a dangerous instrumentality of vehicle.
Sir.
You be careful.
Oh,
Heather, I'm gonna have you adjourn these out a month. Man,
Okay,
you
Judge.
try to come up with $200 by then, and I'm gonna be more than reasonable. Right, okay, Jen, all right, Tabitha, be right there. We'll adjourn it out 4 weeks. I'm gonna send him down there and you can talk to him, okay?
Okay, Judge.
All right, thank you very much for coming with him, ma'am.
yes,
I hope you're listening to me.
yes, I was definitely. Yes.
Good luck. Go down the hall and get your notice if you would, okay? Thank you. Cody James Hartwig, 25W839991. Hartwig? Could I have Hartwig up here? I want Jeanette Stutz up here. I want Hartwig up to the podium. Come on up, sir. And I want Backaroo and Stutz at the table there. Your name? No, I don't want to shake hands with you. Right there. At the podium. You guys have a seat right at the table there. Mr. Hartwig, what's going on? Your name? All right, how you doing?
Yep.
Not too bad. You nervous? Who's this, your mom? What are you, a senior? Charged with reckless driving. You know that? I'm gonna give you a lawyer. We'll put you with a lawyer. We'll give you a we'll give you a lawyer. And that lawyer will talk to you about the case and he'll represent you. And when you come back in, toss your gum out in the garbage out there, okay? Will you please? Fair enough?
Yes, sir.
All right, good luck. Jeanette LaRue Stutz, 25W839823. Your name, ma'am? Charged with open intoxicants in a vehicle. You have the right to a lawyer. If you want one, I'll give you one. Otherwise, I'm going to arraign you and have you go talk to the prosecutor yourself?
Talk to a lawyer.
Okay. Set them both up with lawyers. Backaroo, you go out in the hallway, ma'am. Jennifer Lynn Backaroo, 25W840-116A and B. Name? Drive while suspend, defective equipment. You have the right to a lawyer. Do you want one? I'll arraign you then. And then we'll go from there. It is alleged that on September 18 of 25 that you did operate a motor vehicle with a suspended license in the city of Woodhaven, County of Wayne, on Allen near West. That's driving on a suspended as a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those 2 points. You also have a civil infraction charge of defective equipment. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea, $500 personal bond. You do not have to post any money, but here are your bond conditions. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. We're going to send you to the prosecutor. You go to the prosecutor to meet with the prosecutor. Once you do that, either way, you're coming back in front of me. Okay? Any questions?
No.
All right. So he's going to bring your file to the prosecutor. You can go right outside into the hallway.
Okay.
Monique Lagness. Monique Madeline at Lagness, 25W838-622. Do we know where this lady is?
It's not counting.
Okay.
She's coming in, Judge.
Needs to go to lawyers, prosecutor. You have to start your video, man. Ms. Lagness, you have to start your video. Can you get the deputy, please? People against Patterson. Rashid
Ready, Judge.
Kareem Patterson Jr., file number 25W839530. I'll be right with you, Ms. Lagness. I called another case when you weren't on. Just bear with me. Your appearance, counsel?
That's P7634. Mr. Patterson, we do say it following the judge.
Your client pled guilty to the lesser included offense of operating while impaired. He was referred for a screening and assessment. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
Judge, we haven't had a chance to review it. There are no material additions, deletions, or corrections.
Anything you would like to say on his behalf?
Judge, Mr. Patterson is not having an alcohol problem, as you can see from the
You have
report.
to take your hat off, sir. Go ahead.
See the report, Judge, he drinks maybe once every 2 months or so. This happened at a tough time in his life. His father just committed suicide. He went out to a family and celebrated too much. He drove and got arrested. He takes full responsibility. We got brain on the first, to the plea right that same day. And he wants to put this kind as soon as possible. So we're asking for 12 months probation. I would ask that since he works full time, 40 hours per week, we limit or delete, the court work program, just because he works full time, lives with his family. And minimize the testings because he's going to be clean every single time. So based on that, Judge, he's got trouble with spokesman both times. His sister was here last time. We're a great night for the prosecutor. Yeah, so I think what we need to have, and he just needs family support and deal with his grief with his family. Stay with all that she will do. So I'm just asking that we send some accordingly and minimize the amount of testing and work program. Otherwise, I think the substance abuse class would be great and still with the victims of that panel.
Sir, is there anything at all that you would like to say?
No, sir.
12 months probation. You cannot leave the state without the consent of the court or violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you submit the testing. I'm going to make it bi-weekly for 3 months. If you're clean, I'll then make it monthly, okay? So you have to go bi-weekly for 3 months. If you're clean, I'll make it monthly. I'm going to order that you attend that program as recommended, the substances of abuse group through Class A Training Center. I'm gonna order that you serve 4 days jail credit, 1 serve 3. I'll let you serve those as follows. One day of community service by November the 28th. By the way, you've seen his AA verification council?
Yes.
Has he been going once per week?
Yeah,
He showed that to you this morning?
I showed you this one, but
Let's see it, sir. Your AA verification.
Paperwork there, but I thought I started that once I went to this birthday. Well, so it's my second birthday, start my second birthday.
no, you're supposed to start first. That's why we talked. I thought you went to 2 of them in the last 2 weeks.
What do you mean? Did I just tell you what I was gonna do in the future? October 1, I set your bond. I told you to go to AA once a week. Why didn't you do it?
Because I thought,
Why would I have told you to go once a week if I didn't mean for you to start until another day?
I started once. They, so I don't know.
Did I say that?
I misunderstood you.
Am I doing that bad of a job up here where I'm that unclear, where I try to, come on.
Just like today, accidentally, sorry, I know.
It's probably my fault, and I should have stressed that it was before probation, but I told him he was probably gonna do that during probation as well. After we met with the probation department, we're here till about.
He
almost-
graduated high school, right?
Yes.
He doesn't have any learning disabilities, right?
Oh.
You're gonna do a better job of listening to me, aren't you? Going forward?
Excuse me?
He said, are you gonna do a better job?
Are you going to do a better job of listening to me and following directives, or are you gonna make your own rules here? You make your own rules, we're gonna have a big problem.
Sorry about that.
Hey. It's the 21st century. For whatever reason now, some people think they don't have to listen to what authority says anymore. We have the right to disagree with people. The right to go out in the hallway, say I'm the worst judge in the country, that I was trying to make you go to AA once a week. That's okay, you got that right. But you don't have the right to ignore orders. This kind of thing drives me crazy, because I don't get it. I just don't get it. So let me be clear. You're gonna go to AANA at least one time until you're in the class.
Until he's in the class A.
Correct. So he's starting today. We're giving him another form. He's going to go in person. He's going to have that form signed by somebody there every time he goes, and every time he comes to probation, he's going to bring that form with him. We need an AA verification given to this young man, John. So, do we understand one another a little bit better now?
Yes, sir.
Good.
There was no excuse, but this is his first time I'm being in court, so I'm just gonna. I probably misled him.
How would you have missed one? Come on now.
Just saying, because I told him like, oh, you're probably gonna get assigned to that as well after probation. I just went through what this probation would probably be, so it could have just.
He graduated.
I know, Judge, but
Seems like a very intelligent young man. He's just not paying attention. All right, 4 days jail credit, 1 serve 3, 2 on the court work program, 1 day of community service. I'll give you until November the 28th to pay that or to complete that. Fines are 300, costs are 325, 75 victims' rights fee, $50 justice assessment fee. Your fines and costs are $750, screening 60 for 810. Probation fees are $240 for $1,050 plus your court work program fees. Everything included amounts to $1120. You may be eligible for early discharge if you're compliant. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for appeal purposes. Do you understand that?
Yes, sir.
All right. You have any questions?
Sir.
Anything? Can you pay all this to?
I don't think you can pay it off.
How much does he have to?
Like 50.
Make a payment Friday.
You live with your mother, right?
Yeah.
You pay rent?
Uh,
How much do you earn per hour? You're living high in the hog. $18 an hour and you're not having you don't have to pay any rent. That's a good deal.
we can just move back in.
I'm not trying to be a wise guy. I'm trying to make you understand. You should have come here with some money too, but I'll deal with it. $50 a week is all I'm gonna ask you to pay. You get paid weekly, right?
Good.
I'm gonna start this beginning on Monday. That will be on October the, yes. Now, if you don't have the money, no problem. Show a little respect. Call the court, we'll go on Zoom, or you can walk in here on or before the due date, 8:30. I'll give you an extension. If we have to do that, I don't care how many times, 112, 32, 7, 9, it's fine. Just don't ignore me, okay?
Judge, seeing as he gets paid on Fridays, did he pay the first one this Friday? Would it count for Monday?
I'm just having him not pay on Mondays to give him an extra day to
Okay.
come here. If he wants to pay Friday, he can pay Friday.
Just want to make sure.
And this is your mother over here? Which one?
So,
And who's that with her? See, your mom and grandma are here supporting you, right? But make them proud. Listen better. Take me more seriously or we're gonna have a problem. Best of luck to you. I wish you well. Good luck. Laginus, Monique, and you're gonna meet with probation before you leave here, okay? Thanks. Monique Laginus. Monique Madeline Laginus, file 25W838-622. Ma'am, you have to unmute there? All right, thank you, deputy. Good morning, ma'am. Your name, please?
Monique Lajeunesse?
You're charged with retail fraud and you have the right to an attorney. Would you like an attorney?
Yeah, I believe I would.
Okay.
Court appointed, yes.
Commissioner from probation, we are here today for a violation hearing and a pretrial on the escape charge. And what's our status, Mr. Elter?
Your Honor, speaking with Mr. Allen, he would like to retain me as counsel. Is that correct?
Yes, sir.
And then set this for trial.
Oh, okay. Are we bringing in a jury for this?
Yes, jury trial.
Okay, all right, go see Ms. Idle. Do we have a
I need
time
to do a time waiver.
waiver?
Yeah, I
I mean, he's
He's
being
got
held on
that.
the probation violation, so
He's
it's
got-
1-for-1. I can't see how we have a time problem,
that's
but
correct. He was indicted in August, but I mean, this is the fourth time we've been back on this case, so we're kind of dragging.
Okay.
yeah, I mean, he's being held on the PV, so it's a 1-for-1.
It
So,
is.
all right, go get it set for trial.
Okay.
All
Thank you, Your
right,
Honor.
that's all.
No. If you want me.
Okay, we'll set you up with a lawyer on Zoom. And you will talk to the lawyer, just be patient. Make
Okay,
sure you tell them that she's in custody, will you, John? So they can kind of get to that one, the county. They're not gonna want to have her waiting that long. So you go ahead, just, they'll be in touch with you very soon.
all right, thank you, Your Honor.
Good luck.
Yes.
Can I have Antonio Trevon Revere here? This is file number 25W88674.
Morning, Your Honor, Mike Hill.
Mr. Revere, how are you?
Doing well, yeah, how are you?
Good, your name?
In terms of training,
You were in the military,
correct,
and I thought I read in here somewhere you were in the Marine Corps.
correct.
What are you doing?
Making my decision.
Alright, so he pled to operating while impaired. On September 17, he was referred for a screening and assessment. Have you had a chance to review that report with him? And are there any material additions, corrections, or deletions?
Yes, Your Honor, I have had the opportunity to work with my client. There are no material provisions or deletions, except the court should be aware that he's no longer holding that job as Cintas is indicated. Otherwise,
Why did he leave there?
but he didn't leave. The reason he doesn't work here anymore is because he picked up this charge. It was a driving related job. So because he picked up this charge, they let him go. But he's found new work. We'll talk about that. But yeah, he's not working there. So
Where's he working now?
you know, he it's just been hired over at Clovis in Dundee. He starts on Monday.
Alright. Anything else? Is everything else in the report accurate?
Yes, you know, everything else is accurate. My client understands what the recommendation is. It's fair and reasonable. If this is so, he can comply. We have the court to adopt the recommendation as presented.
Just give me 1 second here, please. Sir, is there anything that you would like to say?
No, no, there.
Okay, so let's just talk about this. You were pulled over because your headlight was out. But what troubles me is you also had a drunk driving when you were in the military, where all they did was give you formal counseling, no conviction, right?
No, Your Honor. They did take an alcohol test when I was in there, and I didn't have anything in my system. So that's why I was never charged. I was only charged with refusing a breathalyzer because it was from a direct order.
I see. Okay, well, it makes a little difference. 12 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, marijuana. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend the substances of abuse group through the Class A Training Center. Attend that, complete that. Also, you're to attend the Victims Impact Panel. No alcohol, no marijuana, no illegal drugs. Submit to chemical testing, PBTs and ETGs. I'm gonna make it bi-weekly for 3 months. If you're clean, I'll then make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. So again, Victims Impact Panel, bi-weekly testing for 3 months, no alcohol, no marijuana, no illegal drugs, no kratom, no poppy seeds, no CBD oils. Substances of abuse group through Class A Training Center, attend that, complete that. Okay. 4 days jail credit, 1 for 3, and I'm gonna only have you do 1 day on the court work program. So credit 1 day court work, $35 a day charge for that. So for $35, and then 2 days of community service, I'll give you until November 28 to 25. You may be eligible for early discharge if you're compliant and you don't have any violations within the preceding 90 days. Fines $300, cost $200, $75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $6 1/4. Probation fees, $240 for 865. Screening fee is $60 for 925. Court work program fees are $35 for 960. And then you have cost of recovery of $150 for a total of $1,110. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. And again, you may be eligible for early discharge. If you violate, again, you could get 93 days. Do we understand one another?
Yes, Your Honor.
All right. Do you have any questions on the sentence, sir?
No, Your Honor.
Can you pay all of this?
Your Honor, I can't pay that today.
How much does he have today?
Your Honor, we propose paying $100 today. He's asking for a payment arrangement where he can pay, I'm sorry, he can pay the $100 by October the 20th, Your Honor. He's got some money coming in. And he's asking to pay $75 every 2 weeks thereafter.
Where's he working again now?
Just got a job at Culver's.
All right, $100 by October 20, $70 bi-weekly, beginning on November the 3rd, okay?
Yes, sir.
If you ever need more time, just come talk to me. I'll be happy to give you the extension on it before the due date at 8:30. If you would prefer, you can call up and we'll Zoom on or before the due date at 8:30, okay?
Sounds good. Thank
Best
you.
of luck to you. Thank you. Tyrus Travante Bryant, you'll meet with probation before you leave. This is 24B 716-3361. Okay, your name, sir?
Area Brian,
Fair to pay fines costs, $9.25. That's the charge. What's your name, ma'am? You're his mother? Okay, okay. Okay. Mr. Bryan. You're charged with fair to pay $927. If I find you didn't pay and your fair to pay was not without your fault, you could be incarcerated for the balance. Do you understand that?
yes, Your Honor.
Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial of any kind. You understand that?
Yes, Your Honor.
You have the right to an attorney. If you want one, I'll give you one. Would you like one?
Yes,
Set him up with a lawyer. Not guilty plea is entered. How many days did you serve on this case initially?
45.
Yeah, so, yeah, you have 320 more days you could get in jail. Do you understand that?
Yes, sir.
Why didn't you come and talk to me? When I tell everybody what I just told him and then the last guy. Why didn't you come and talk to me?
I have other probations that I'm paying on, and
Did you come talk to me?
no, Your Honor.
Did I tell you to come talk to me if you didn't have the money?
Yes, sir.
Why didn't you do it?
Because I was in CBT, which is flip the script, and that was a mandatory program that I had to be at Monday through Thursday.
We'll give you a lawyer. How's that? And then you guys can come in here and tell me everything. But again, you just can't do this. I don't have a problem giving you extensions.
I made a payment too, Your Honor. On the website, the payment is all the way down to $800 now. I have been making
You were
payments.
supposed to pay $75 a month beginning in June. All right, go talk to your lawyer. And you come back in front of me, okay? Attorney here. Thank you. Tarrant? I'm Earl Tarrant. 25W8396608 B. 24W8371948 23W8325968. How you doing?
I'm doing well, sir.
Okay, so what brings you here?
Well, the last time I was in front of you, I was in jail for 4 days for a ticket. The officer put me over for, so I came for you for some unpaid tickets. But I was unaware of this ticket he gave me for legal term and no proof of insurance. So these tickets went to default. So I came in yesterday. They told me to go to the police station and try to get it, but they said it's in default. So I came to you today in front of for the open court to see how.
Well, you can file a month. I don't know how you weren't, hang on, slow down. I don't know how you weren't aware of it. At least the officer's telling me he declares under penalties of perjury that the statements are true and he served a copy upon you.
No, I sat right here. I was ready.
I'm talking about August 22nd. A citation was issued to you for prohibited turn improper return and no proof of insurance, 2 charges.
I know, I got these, I never got them when I was originally arrested. I was never, I came in front of you, you addressed the tickets because I was arrested, but I didn't pay the fine, my original fine. So when I sat right here that day, you only, you gave me the situation for paying, so when I got home.
Slow down. Let me take a peek.
I was in jail.
Slow down. Slow down. I didn't address it because I didn't have it in front of me. You were in front of me on September 5th, August 25th. That was 3 days after you got the ticket.
Right, I was in jail.
Stop. Slow down. Okay. And then what happened?
Then, after you let me go, so,
I let you go on August 22nd, right?
told me I had payment plan, so I was under the impression that I never knew about these tickets.
He didn't give you, slow down. You gotta slow down. Slow down. You came in front of me on August 25th.
Yes, sir.
These tickets that you're referencing were issued on August 22nd, 3 days before. Do you agree with that?
I don't recall I get, that's what I'm saying, I don't recall getting these tickets, I don't recall making no illegal turn over it.
Well,
And the reason that
the officer's saying he gave you the tickets. Did you live on Carmel Street at one point?
I still live in.
I mean, all I can tell you, if you want to file a motion to set aside the default judgment on these, you can go down and post a bond that's the equivalent.
That's why I'm here today.
You can go down and post a bond that's the equivalent. That's what the rule says, sir. And that's what you would have to do.
Never made this turn. I never was aware of these tickets. I sat in jail for 4 days. No one told me about the reason I was pulled up, he said, the only reason I was pulled up because I owed a ticket for you. I never was asked for I never made a wrong turn. He pulled me off just because he had a district pulling me off. He said he pulled me off because he ran my plate and seeing I had a ticket, a warrant for a ticket. So as I said it,
So you're saying you weren't pulled over?
I was pulled over, but not for no wrong turn. He pulled me over because he said he ran my plate and I had a ticket for you, a warrant for you. So I was took to jail. And I sat in the precinct for 4 days, and that's when I came to you that day.
On the 25th.
Then after that, I was only under the impression I was on the court for those tickets. So when I got done with that, I'm trying to make these payments, and I get these. Like, where these tickets come from?
When did you receive those?
I'm not even sure. That's why I said I'm not even sure when I got these. My wife just happened to have.
You work?
I just got the job yesterday. Even still, right here in the.
Well, what's the problem with you posting a bond? That's, slow down. Just slow down and don't lose your temper because I'm not gonna have you yelling at me here. He says on the bottom of this, the officer, I served he checked the box.
He never did that. He's lying. He never gave me nothing.
All right, slow down. I served a copy of the civil infraction complaint upon the defendant, owner / occupant by posting if applicable.
Well, I'm telling you, Judge, I come see you all the time at dinner. The only reason I'm
Just slow down, Mr. Chairman. I want you to slow down. Is there a reason you can't post this bond?
Got a job yesterday too. I didn't make this turn. I never made a legal turn. I have a ticket for no reason. I never made a legal turn. The turn I made right here, that's it, at the Woodhaven precinct. You gotta turn, make it blink and turn to get to the freeway right there. You pulled me over at the freeway.
Slow down. So he did pull you over.
Yes,
You acknowledge he pulled you over.
yes. But it wasn't for a legal turn. He seen me come from Wall Road. He made a U-turn. He came, he's noticed my car. He has a history of pulling me over.
A
Once
history.
he got in front of me, behind
See
me.
if Officer Pazlako's working, John. Call over to Woodhaven, please, right now and find out if Pazlako's working. Yeah, that's what the rule says, is if you are in default, you have to post a bond.
know that, John, but I never knew I had to teach. I never knew it. I never knew about this.
You hadn't ignored us so long, you wouldn't have spent 4 days in jail. You know that, right?
Yeah, that was for your first tickets. I'm talking about.
I'm just telling you.
I know, I understand that.
I'm just telling you. You just can't do these kinds of things.
What do you mean?
You can't not show up. You can't not show up. I even offered you,
I know you told me that when I was in school then. About that. We talked about it.
I'm just telling you, you don't show up in court. You didn't show up here in November of 24. We had to issue a warrant, and you also didn't show up on another day. Where do you work now?
Eaton Steel and Taylor. On that Trolley Avenue or Trolley Road. And Monroe Street.
I'll tell you what. I think you create some of your own problems. I know, you can look at the ceiling. You should have never had to spend 4 days in jail, but you didn't show up in July of 25.
Yeah, I understand that.
Okay, then don't look at the ceiling when I'm talking to you. Act like I'm a dummy. I don't like that.
I'm sorry, John, I'm just kind of frustrated.
Well, okay, I can understand your frustration, that don't take it out on me. You caused a lot of this. I tell you what I'm gonna do, Mr. Terrence. I'm gonna just make a note. Defendant insists he was not given tickets. Heather, I would like you to allow him to file a motion to set aside the judgment. And we will then set that for
So you just want him to do the paperwork, Judge, without posting the bond then?
exactly. So,
Okay.
so let defendant fill out motion to set aside default judgment. I will not require a bond, and he needs to write that right in his defect, motion to set aside the default judgment. And the only reason I'm not requiring a bond is because you're insisting you didn't receive the tickets, which I doubt. But it's a possibility that I don't think he would have given them to you, or he wouldn't have checked the box, but there's a possibility, since you were taken into custody, that maybe something went around, okay? So I'll let you fill out a motion to set aside the default judgment. You don't have to post the bond, and we will go from there.
Thank you, sir, I appreciate that.
Come back here a little bit more humble next time, will you please?
Yes, sir.
All right, so Heather, give him a date. Well, actually, no, you go ahead and do that, and fill out that motion, and then we're just gonna set it for a motion to set aside default and
then-
a department rep hearing with Woodhaven.
Okay, so we'll have him file the motion and then we'll set it for a department rep.
And motion to set aside the default judgment on the same day.
Okay,
Okay?
okay.
Good luck. Go down the hall and talk to them. Scott, Luke. Tackett, 199-74701. Where's Mr. Tackett?
Good morning, Your Honor. Attorney Corey Westmoreland, apparently that Mr. Tackett.
Mr. Tackett. Your name? Where were you? Where was he?
He thought his court date was today, so that's why he couldn't do it.
Mr. Tackett. What year was this ticket issued? Yeah. How patient do you think I'm gonna be with you? When you didn't show up here?
I had a full day with you about a week ago.
Mr. Tackett? If you're gonna get yourself in trouble, at least keep your court dates straight, will you please?
Yes, sir.
What'd Ferris Bueller say? Or no, the principal, I weep for the future. Do not issue warrant. I'm sorry, reschedule this one. Give me a date, Heather, when Groziel is here again.
There should be a sheet on there, Judge. I believe I put a date on that one.
Sorry,
When there's 10:22.
10/22 of 25. Do not show cause the surety. Do not show cause the surety. You're lucky. You're gonna show cause your surety company that posted the bond. Don't miss again. Go down the hall, get your notice. October 25th at 9:45. Do we understand one another? Wait a minute, excuse me. October 22nd at 9:45. That's 1 week from today. Go down the hall, get your notice, okay?
Thank you, Judge. Have a nice-
Thank you, you too. Amy Lynn Polavino, fire 25W840101. Can you come up here, Davion Demps? Have a seat at the table? Is this a Woodhaven?
Have a seat here.
Yes. John, take this to the Woodhaven prosecutor. Amia Marie, I'm sorry, ma'am, your name? This one needs to go to Woodhaven prosecutor. He needs to fill out a motion to dismiss.
Okay.
If that's what he wants to do. You're charged with leaving the scene of a property damage accident. Would you like a lawyer?
Yes.
We'll set you up with a lawyer. Go out in the hallway. We'll set you up. You speak with the lawyer. Either way, you're coming back in front of me, okay?
I'll be here.
All right, good enough. So don't go anywhere, just out in the hallway. Amia Murray Fisher, 25W840091. Good morning, Ms. Fisher. How are you today? Your name? Amina what? All right, you're charged with driving on a suspended. You have the right to an attorney. Would you like one?
No.
I'll go ahead and arraign you and let you go speak to the prosecutor, okay? On September 20 of 25, it is alleged that you did operate a motor vehicle on West near Ford Lane in Woodhaven. On September 20 of 25 at 9:27 PM, driving on a suspended is a misdemeanor punishable by up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yeah.
And did you sign the advice of rights?
Yeah.
Did you read it and understand it?
Yeah.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yeah.
You still wish to waive your right to a lawyer?
Yeah.
I'll enter a not guilty plea, $500 personal bond. So you're gonna go talk to the prosecutor. If the prosecutor doesn't give you what you'd like, then you can come back and say, Judge, I want a court-appointed lawyer. But here are your bond conditions. If this doesn't resolve, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You understand all that? So you go out there and we will give you your court date, okay? Any questions? All right, go right outside. Thank you. I mean, we're gonna set you up with a lawyer is what I meant to say. I'm sorry.
She needs a prosecutor's attorney.
Yeah. Prosecutor, I'm
We
sorry.
have seat Paul.
Prosecutor. Ermilis Orlegurns, 25W839412, 25W839999. His lawyer's Foster Tucker.
I'm sorry, Your Honor. I just got in the Zoom room.
You're good. What's your name?
Sherilyn Foster Tucker.
All right. Are you the big shot over there or you got, or is this a sole practice or you got a bunch of lawyers?
It's just two of us. I work for Sam Bernstein, but
Oh, okay. Well, I'm just having fun. You're gonna plead to impeding. You've talked to the prosecutor. There's gonna be a plea to impeding on each of these, right?
that is correct.
And then they're going to dismiss the prohibited truck route and the speeding, right?
Yep,
And you're authorized to enter these pleas on behalf of the company, on behalf
Yes,
of the
I am.
defendant?
yes, I am.
All right, to the charge impeding on file 25W8399999, responsible or not responsible?
Responsible.
And to the charge of impeding on 25W839412, responsible or not responsible?
Responsible.
Okay, I just need to check one thing. I'll accept the pleas, dismiss the original charge of prohibited truck route on the file ending in 999, and I will dismiss the speed on the file ending in 412. I just need to check one thing here. Okay, the bond on 839412 is under his name. I'm gonna assess fines and costs of 210, and we are going to apply the bond on that one. Okay, do we understand?
Okay.
You understand that? And then
Yeah,
on the other case, I'm gonna assess fines and costs. I'll make those 210, but I don't believe he posted a bond on that one.
I don't
Did he?
believe so.
So I'm gonna give him a week to pay on that. So he has to pay on that one by October the 22nd. Is that enough time?
That should be.
Okay, so you're all set. We'll apply the bond on 9412, Heather. And then we're gonna give him time to pay until October 22nd on the prohibited the impeding charge, the other one that was initially charged as prohibited truck route. You're all set, counsel. Nice to have you here. Take care. Thank
Thank
you.
you. You too. Have a good day.
People against Baker Root, Jennifer Lynn Baker Root, T5W8401116A and B. Your name?
Jennifer Baker?
You're gonna plead the no ops on person, is that right?
Yes.
And the suspend, revoke, deny is going to be dismissed, true? If you do that, possible penalties on this are up to $100 fines, 90 days jail, costs are all those. Do you understand that?
Yeah.
And did you sign an advice of rights form here today and read it and understand it?
Yeah.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that? To the charge, and you have the right to an attorney. If you cannot afford one, I will appoint you one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No.
To the charge, no valid operator's license on person, how do you plead?
No. Guilty?
Well, I don't want you.
I didn't hear you. I'm sorry.
To the charge of no valid operator's license on person, how do you plead? Were you operating a motor vehicle September 18 of 25 on Allen near Western Woodhaven? Did you have a valid license on your person? It was revoked, true?
Yeah.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted. The suspend, revoke, denied is dismissed on motion of the prosecutor. Why haven't you gone and tried to get a license?
I did, and it was denied.
How long ago?
6 years.
You need to go back, man. You're gonna you can't be driving, I don't know what to tell you. Okay? Anything else you want to tell me? You can't drive on a revoked, 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 or 60 days. Go get a license.
Okay.
And by the way, I should indicate on here that the defective equipment as part of the agreement is also dismissed on motion of the prosecutor. Okay, so that case is dismissed. Can you pay the 4 1/4?
Today?
Yeah. How much money do you have with you?
100.
When can you pay this?
2 weeks?
Where do you work?
I work for a cleaning company. I own my own cleaning company.
I'll tell you what, you pay 75 per week. How's that?
Okay.
I'll start that beginning October 27th, okay? If you need more time, call the court. We'll go on Zoom on it before the due date, or you can walk in here on it before the due date. I'll give you an extension, okay? Good luck to you. Wish you well. Go talk to a lawyer about getting your license, though, please.
Yes.
Keith Lenar Harris II, 25W8402004A and B. Yeah, man, what do you have here again? What's your name? What happened to that file? Were you in front of me yet?
You gave it a file to John. I didn't even read your computer.
Your name, sir?
Pete Harris.
Come on up to the podium. You're charged with driving on a suspended. You have the right to a lawyer. Would you like one?
Yes.
Okay, we'll set you up with a lawyer. Okay? You go right out in the hallway. What's the name of this gentleman's name again?
Yeah.
Demps?
Yep, take down depth.
I didn't call it?
It was up there.
Did I call
No, the prosecutor needed to look it over. You had John take it back there.
it? Oh, I see. You go talk to the prosecutor. That's on the case where they're probably gonna end up dismissing it today. Go right outside there. I'm gonna send this young guy, just wait 1 second.
From the prosecutor's office and Officer Kell from probation. We're here today, Mr. Stacy, because I've received a report that alleges you have violated the terms of your supervision. The allegation is that you absconded from supervision back in 2021. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by an attorney?
I need one.
Are you going to hire an attorney or do you want one appointed?
One appointed.
Ms. Carrillo has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. Sorry, who was that? I do find that you're indigent for the purposes of hiring a lawyer. I'm going to appoint Ms. Hinkle to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed, and I'm going to set this for a final hearing in about a week to 10 days. Anything you want to tell me today?
No, sir.
All right, court finds there is probable cause to believe you have violated the terms of your supervision. I'll see you in a week or so. The State of Ohio versus Jacob Rutherford. This is case number 23 CR 40789. Present before the court is Mr. Rutherford, right?
Yes, sir.
And we have Mr. View from the prosecutor's office and Officer Kell from probation. We are here today, Mr. Rutherford, because I've received a report that alleges you have violated the terms of your supervision and that you did not complete the Genesis program and left that program without permission. The recommendation of probation is that I send you to the Monday program. Apparently, you've been accepted. Once we get the medication issues squared away, we'll get you over to Monday. If that's the way we go, you have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
Yes.
You're going to hire a lawyer or do you want one appointed?
I don't have the money, so.
All right, Ms. Carrillo has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed.
Sorry, who was it?
Mr. Gibbs?
Gibbs. Right here, man.
I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. Gibbs to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed, and we're going to set this for a final hearing in about a week to 10 days. Is there anything that you would like to tell me today? All right, I do find there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the final. I'll see you in a week or so.
God bless.
Case of the State of Ohio versus Kerry Hofler. This is case number 25 CR 42356. Present before the court is Ms. Hofler, right?
Yes.
We have Mr. View from the prosecutor's office and Officer Kell from probation. We're here today because I've received a report that alleges you have violated the terms of your supervision, that we have some new theft charges coming out of Mason, that you were positive for cocaine and abusing your Suboxone Full Circle, that you left Full Circle in August of 25, and that you admitted to using meth in October of 25. The recommendation for Officer Evans is that I continue you on probation into some sort of treatment program, maybe someplace different. So I am going to be setting this for a final hearing in about a week or so. Do you want to be represented by a lawyer at that hearing?
No.
All right, Ms. Kuroko has a waiver that tells me in writing you don't want to be represented by a lawyer. Do you know, Officer Kell, have we identified an alternative treatment place yet or not?
It doesn't appear so. She's recommending hold in jail to assess for a higher level of care.
I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit.
Based upon your admission, I find you have violated the terms of your supervision. I'm going to hold you in jail till next week. You and Officer Evans or Ms. Wilkerson are going to put your heads together on a recommendation of where we're going to get you. I want to keep you on probation. I want to get you back into treatment, but what we were doing wasn't working. Okay? All right, I'll see you in about a week to 10 days.
Thank you.
Next is versus Raymond McDonough. This is case number 25 CR 42406. Present before the court is Mr. McDonough. We have Mr. View from the prosecutor's office and Officer Kell from probation. We're here today, Mr. McDonough, because I've received a report that alleges you violated the terms of your supervision. The allegation is that you tested positive for meth on October the 14th and that you didn't do the treatment that you were supposed to do. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Yeah.
Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. What's our jail days?
He is at 100 days.
I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated the terms of your supervision?
I did.
Based upon your admission, I find you have violated the terms of supervision. What do you want to tell me? I think you told your probation officer, who cares if I use meth? I'm 73 years old. Is that still kind of your position on that?
Yeah.
All right. Mr. View, anything from the state?
No, Your Honor.
Officer Kell?
I have nothing additional, Your Honor.
All right. Anything you want to tell me, Mr. McDonough? Nothing?
Yeah.
All right. It doesn't make sense to continue supervising you on probation. Court's going to order that you serve 125 days in the county jail. I'm going to credit you the 100 days you have already done. And when you're released from jail, we got 25 more days to do. When you're released from jail, you'll be free from any further obligations of the court. I'm hesitant to ask this in this way, Mr. McDonough, but do you want me to make you eligible for the litter pickup program? Do you want to go out and pick up trash or not? Yeah. Okay. All right. Good luck to you, Mr. McDonough.
Your Honor, what type of termination would you like for him?
Neutral.
This way.
Yeah, we'll head out this way.
CR 40246. We are on the record for the purposes of an early termination hearing. Mr. View, anything from the state?
Your Honor, we did receive a response from the victim on the case. He has been made whole in terms of restitution and indicated that he did not have objection to termination.
All right, we're going to grant the early termination of supervision for Mr. Harner. Next, Ohio versus James Westbury. This is case number 23 CR 40582. We are here for an early termination hearing. Mr. View, anything from the state?
Your Honor, this is a very serious offense. It's a second-degree felony aggravated arson. Given the circumstances of that, the state would be opposed to early termination of supervision. Additionally, we did receive information, a victim impact statement that I believe was forwarded to the court from the victim in the case, Ms. Walmsley, indicating her concerns regarding the defendant and concerns for early termination. Based upon those things, we would oppose the motion of probation.
All right, I am going to grant the request for early termination. Are we going to bring Ms. Tranter in and also get Mr. Thomas brought around?
Stranger is right here, Judge.
Oh, I'm sorry, I didn't see you, Ms. Tranter. You were tucked in behind Mr. View.
That's my goal in life.
We are on the record for the purpose of an early termination hearing. Mr. View, anything from the state?
I'm sorry, I thought I was done with audio.
Nope, we have Cronenberger.
I didn't have that on my calendar, I'm sorry. Is another termination case or?
It is.
Okay. I only had the two, Harner and Westbury. You have the docket. Cronenberger's the name?
Yes. This was somebody writes a check to themselves and tries to cash it on a company account. No money was received. ILC, no issues. No prior criminal record for the defendant.
It's a successful termination on ILC.
Yes.
Gabriel Cronenberger?
Yes.
Okay. All right. I mean, if it's a successful ILC, I don't know that we have a position.
All right, I'm going to grant the request for early termination of ILC. All right, that's all.
Morning, Judge.
Good morning, Mr. Yurick. How are you?
We are well. How are you, Your Honor?
Good, thanks. I have this Mr. Demps sitting here. That was a motion for early discharge. It was taken under HIDA.
Just called his name out.
Yeah, go out. He's right in the courtroom. He's right in the courtroom. Sir, go right into that first conference room there, right out the door to your right. Okay, I'm sending him in now. He was sitting at council table. Thank you. Tabitha, I gotta start getting court this. I feel okay. All right. 5-minute recess.
They should concuss.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, I do, Your Honor.
All right. So to the charge retail fraud, how do you plead?
Guilty.
On April 29 to 25 at 12:05 in the morning, were you at 21860 West Road in Woodwood?
Yes.
What kind of store is that, ma'am?
Circle K.
And did you walk in there and steal bottles of liquor and walk past the register without paying for them?
Yes, I did.
Are you on probation or parole?
Not at the moment. No, I've taken care of all that.
Anybody forced you to plead guilty?
No, Your Honor.
I'm gonna accept your plea. What are you in, for retail fraud? What are you in custody for?
Not showing up for court, Your Honor, in Riverview. On a
Why are
retail.
you waiting? Were you sentenced on that case?
Yes, I'm sentenced to 90 days and I'm here until October 25th, next week.
He's been incarcerated, Judge, since August 8th.
Let me see this record of hers if I can. Does she work?
Are you employed in that?
You work?
I take care of my significant other's father. For the time being. For
right.
an exchange for housing.
All right, I'm going to accept your plea. I'm going to set a $1,000 personal bond. No contact with prosecution witnesses. You're not to enter that property address at 21860 West Road in Woodhaven. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those, or marijuana. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I'm going to order a screening and assessment. Defendant to appear in court. Heather, maybe you can give probation a heads up. Defendant to appear in court to meet with probation. First business day following her release from jail. Now, you don't need to get scared. I just want to find out a little bit more about you, okay? And we're going to set a sentence date. And the sentence date, I want like a week after that. So about November, whatever the first Woodhaven docket is with me in November, Heather,
So that'll be November 12th.
at 8:30 in the morning. So you're going to get out of jail. You're going to come up here. You're going to meet with probation. You're going to fill out a questionnaire and be interviewed. Then you're coming back for your sentence on November 12th at 8:30. Okay?
All right.
Any questions?
No, can you tell me that date one more time?
November 12th at 8:30. And and we're going to send your notices unless you tell me differently to the same address on Robinson.
No, that is the incorrect address.
What's your address?
19690 Fort Street, F-O-R-T Street, Riverview.
What's the zip there again?
I believe it's 48195.
Okay.
It could be
All right,
6.
we'll send your notices there. Have a great day. Good luck.
Thank you.
David Estelar Gonzalez, 25W836565. Mr. Estelar, your name? You're charged with failure to attend the court work program on September the 27th of 25. If you plead guilty or if you're found guilty, this would be your first technical violation. You could get 10 days on or 5 days on this. Do you understand that? And did you sign an advice of rights form today?
No.
You're presumed innocent. You have the right to a hearing. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. Do you understand that? Yes?
Yeah.
If you plead guilty, you're giving up all of those rights. Do you understand that?
Yeah.
You have the right to a lawyer. I'll be happy to provide you with one at public expense right now. Would you like a lawyer? You waive your right to a lawyer?
Yes.
You understand all your rights? To the charge you failed to attend the court work program on September 27 of 25, how do you plead?
No comments.
It's either guilty or not guilty.
Not here.
You want to have a hearing as to whether or not you were there?
I was there.
Okay, we'll have a hearing. Call in Emily on this one, please. You can have a seat at the table right below, right behind you. I'm entering a not guilty plea, and we are going to have that hearing in about 3 minutes. Have a seat right at the table here, sir. People against Davion Carice Demps. This is file number 24W834260. Mr. Demps, your name? I'm going to ask you to raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you've given these proceedings will be the whole truth, so help you God. You swear to tell the truth?
Yeah.
Where's the sentencing? I don't even see a sentencing on it. Were you sentenced on this?
Yes.
Who was your probation officer? Jessica? Emily?
Emily, yes.
Tell Emily I need the sentence. I don't know what happened.
Client ever told me.
I thought the sentencing was attached before.
Good morning, Judge.
I could not, tell you for sure, but I thought the sentencing was attached to Dempsey's register and I don't see it. You have it?
Your Honor, when you say Dempsey's register,
The probation register of actions. I don't know what happened to it.
I thought there was a regular, court ROA.
Yeah, I know, but I don't have the sentencing. I don't have the sentencing. I'll get it from Emily. I'll get it from Emily.
Was paid.
I'll get it from Emily. Thanks. Yeah, but I'm sorry. Charles Lester Laney, 25W839-811 A, B, and C.
Good morning, Judge. Matthew Gift, on behalf of Mr. Lane.
Mr. Laney, good morning. Your name? You're retained on this, right?
Correct, Judge. We're just asking for some time for the discovery.
Okay. I'm signing the discovery order. We're gonna adjourn this a couple weeks. What date do you have for me on this one?
Judge,
That'll-
can we get 3 weeks? Can we get 4 weeks? I have a couple of trials coming up and I just.
Okay, okay. Give me 4 weeks.
All right, November 12th at 8:45.
November 12th at 8:45. I've signed your discovery order, okay? Thanks a lot. November 12th at 8:45, sir. Go down the hall and get your notice, please.
Thank you.
All right, thank you. Mumar Syed. 25W8401968. Come on up here, sir. Name? Drive while suspended is the charge. You have the right to a lawyer. Would you like one?
Yes.
Okay, we'll set you up with an attorney. You can go out in the hallway, okay? Go right out in the hallway and we'll set you up. And then either way, you're coming back into the courtroom after you speak with your lawyer and he or she speaks with the prosecutor. Heather, do you have the ROA on Demps? I don't know what's going on with this.
I do not, Judge.
You see Judge Kirsten Moore. It just means that it would. Michael Jackson.
That was put there. It was sitting there, that's why I gave it back to you. She's done.
Back on. Mr. Istelart, come on back up here. David Istelart Gonzalez, people against David Istelart Gonzalez, 25W8366565. Your name? I hate to do this. I've got to leave. And I should handle this case. And the probation officer is meeting with the probationer. Okay? So I'm gonna let you kind of tell me what a date is good for you to come back. I'm sorry, I've got to leave. I'm not doing this to be spiteful or anything. Can you come back here in a week?
I need at least 2 weeks notification.
Okay. I'll adjourn this to October 29th. Okay, my apologies, and I mean that sincerely. Pardon?
That's the guy, he was just in front of the judge, wasn't he?
I guess the judge told him that he needed to come here and get a date.
Heather, wait a second, I can hear you.
Sorry, Judge.
Can you request a what?
And I request assume it's a second time I don't give to you.
Assume?
Yeah.
I don't know what you, a what?
Assume or impose.
What?
Zoom.
Oh. Yeah, I'll let you do Zoom that day.
Then I can do it next week. The problem is.
That's fine. Make it October 22nd. Heather, give me a time next week. I really mean this. I'm apologetic about this. I've got to leave. So I'll let you do it by Zoom.
Okay.
What day,
On
Can you
October 22nd, Judge?
yeah,
All right, let me take a look at your.
let's just do it at 8:30 and
Yep.
I'll do it and make sure that his notice says can appear by Zoom. Okay?
Okay, Judge.
Sorry about this. Go down the hall. We'll give you your notice. Thank you. Court's in recess. Mr. Demps? Okay.
So be right with you.
You state too, right? Yes, yeah, we're having a rotation with the judge. So hold on one second.
Provided with a phone number to speak to Mr. Gdan this morning, which I did call and was able to speak to a front desk person who did transfer me. That phone number then rang for 2 minutes and then disconnected. So I was unable to actually speak with my client as well this morning, sir. So I do apologize for that. I made every attempt I could. I know his out date is some years out, so I'm just asking for an adjournment.
May I address the courts real quick, please?
You are. Go ahead.
I was just gonna say, I haven't spoken to my lawyer since my last adjournment on August 6th, and I was just trying to say, I'm at this facility now, so if y'all don't have the addresses, they can give it to you. I never got no mail, and I wanted to be able to talk to my lawyer in the breakout room because I don't want to adjourn.
Well, I'm not going to give you a breakout room. Your counsel just explained everything to the court. I'm going to adjourn it to November 5th, 2025, 9 a.m. She's trying to get in touch with you at the facility.
I want
All
to
right?
request for a speed trial. Can I say that on record?
Okay, that will be considered. I'll wait for the written motion.
Thank you, Your Honor.
Thank you.
Sir, we'll be in touch.
Court does call the case, People versus Lawrence Peck.
As calls for the people.
Your Honor, Joe Simon on behalf of Mr. Peck, making his way to the podium. State your name, Larry.
Lawrence Peck.
All right.
Your Honor, we have two reasons to be here today. One is the violation and the court's amended order. Before we get to that, I will tell you that Mr. Peck, as you may remember, was being screened for acceptance into the 15th District Court Sobriety Court. He is going to enter that court. There's a little bit of transition with the probation agent in that court. There's a new one coming in, and Ms. Johns is retiring. But we hope to resolve this case and his PCC before you on the 23rd in combination to effectuate that remand.
Okay.
So I think what Ms. Feltus and I talked about is adjourning this pretrial till November 5th, which would probably be moot anyway after the 23rd.
Got a correct statement.
That is, Your Honor, there's a pending attempt, resisting or obstructing that arises out of the same instance, so.
Well, I'll adjourn the pretrial and bond violation to November 5th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Okay, from outside. Okay.
Court calls the case, People versus Michael Heed.
Ashley Feltus for the people.
It's an arraignment.
Yes.
Thomas Heed, for the defendant who's approaching, Your Honor.
Your name, sir?
Michael Heed.
What's the relationship?
He is my older brother.
Okay, I'm welcome. All right.
We're here for an arraignment and pretrial,
Yes.
Your Honor.
As to the arraignment, you waive formal reading, stand mute.
Yes, Your Honor, we do.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. All right, where do we want to go from?
Your Honor, we are, of course, as the court stated here for the arraignment, I think if I recall correctly, we had discussed adjourning this case to see if we could work it out short of.
Yes.
Will November 5th be a good date for you?
I'm here all the time.
Okay. Yes, November 5th will be a fine date, Your Honor.
I'll adjourn this then to November 5th, 2025. 9 a.m. As to bond in this case, I will set his bond at $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
I do, Your Honor.
Is there any reason that for you? The no-go to is going to be a bit of a difficulty only because you live on Clark Road.
I do, Your Honor.
So what I'll do is you're not to go to or enter the Clark Road address, the 40.
Your Honor, he lives there.
I just said that.
Okay.
If you let me finish.
Okay.
I'm going to say apartment 313.
Okay.
All right. Thank you. Was there a no contact that you wanted or no?
Yes, Your Honor.
All right, with,
It's on the bond.
is it?
Erica Hogan,
I'm sorry.
Erica Hogan, ERIKAHOGAN.
We have that on the non-form. I put it on this side. They did. Can you put that on this form? No contact with Eric. and not to enter IDD address for this apartment 330. All right. Okay,
Thank you, Your
thank you.
Honor.
Thank you. Court does call the case People versus, is it Sudhil Singh?
National Office for the People.
Good morning, Your Honor. Joseph Wagner on behalf of Mr. Singh, who was, state your name.
Sukhdal Singh.
Your Honor, we're here for two reasons today. One is an arraignment, and we waived the reading. And I'd ask you enter a plea of not guilty for my client. And we understand there's a pretrial that I've spoken to the prosecutor, and we've agreed to adjourn it until the 5th of November.
Defendant having waived formal reading. This is, my stickers are all out of order, folks. Defendant having waived formal reading. Asking that a not guilty plea be entered or enter that not guilty plea. Pretrial in this matter will be adjourned to November 5th, 2025, 9 a.m. The bond in this case, bond will be set at a $5,000 personal recognizance bond. Order standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or illegal drugs. I will also indicate at this time, he's not to enter any Sam's Club in the state of Michigan. All right. Thank you.
Thank you, Your Honor.
Court calls case People versus, is it Bella? That's a lot. Is it Liu?
National Office for the People.
Good morning, Your Honor. Alexander Romanowski with and on behalf of Vessel Leo. Your Honor, this is the time and date set for arraignment pretrial. With regards to arraignment, we waive formal reading of the charges and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Go ahead.
With regards to pretrial, we've come to an agreement. The agreement, the plea form has been submitted.
I haven't, and it indicates defendant would be pleading to, is he pleading guilty or no contest? Because I don't have the box check.
And we're going to be
pleading guilty to the charge of retail fraud in the 3rd degree, the 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is an agreement that the prosecutor will recommend HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Okay, have him sworn.
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
That's a lot for you.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
That's right.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you, and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of February 24th, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what'd you do at the Target that makes you think that you're guilty?
I took stuff that did not belong to me.
You went into the store, you took stuff and tried to walk out without paying for it?
Correct.
What kinds of things?
Miscellaneous dorm items. Be more specific. I guess there was bedding.
You're a student
Correct.
and you were taking stuff for your dorm room?
Correct, Your Honor.
Store was open to the public at the time.
Sorry?
The store was open to the public at the time.
Correct, Your Honor.
You didn't have anybody's permission to take that property, did you?
Yes, Your Honor. Or, no, Your Honor, sorry.
And let's make sure we have that.
Yeah.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
All right. And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of your sentencing, that you would not be entitled to the court would not be bound by any sentence recommendation. And the court would not be bound by any evaluation. You understand that?
Yes, Your Honor.
You understand also that we're committed that you would also not be entitled to withdraw your plea.
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, retail fraud. Third, count 1 is dismissed. Pre-sentence investigation is ordered. Defendant is referred to probation. Pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. I said at 9 a.m. 9 a.m. or as your invite indicates. As the bond in this case, I'll set his bond at a $5,000 personal recognizance bond. Standard conditions, including no assaultive behavior. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
I'm also going to indicate at this time you're not to enter any Target store in the state of Michigan. You understand that?
Yes, Your Honor.
Your Honor.
Thank you. Court does call the case People versus Brandon Bovee.
Ask for this for the people.
Your Honor, David Chan, on behalf of Brandon Bovee. Brandon, can you please state your name?
He did.
Way ahead of me.
Shan, you were hiding on that side. You know something? You're never on that. You're always over there somewhere.
I've been trying to go on the side of justice and light, Your Honor, so under
Wow.
this side is a little.
No, I'm not even going there. Go ahead. Did I said anything?
Tentatively, he is accepted into Lenawee County Treatment Court. He needs to get he needs to get screened and assessed by their treatment team to make sure that he's qualified. I did actually talk to Judge Shadler yesterday, so it looks like it's going to be something that we can do, but he has to go through the process. And I understand the next date is the 5th of November, which is 3 weeks. I don't know whether that's enough time to get screened and assess. The treatment team meet, recommendation made, and acceptance happen.
What's my next date after that?
November
19th will be fine.
And there's something I need to talk to Mr. Shand about as well, Your Honor, so thank you for the 19th.
All right. November 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Salvatore Lorenzo.
Ask for this for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Sal Lorenzo. Bless you.
Bless you. Your name, sir?
Salvatore Lorenzo.
Thank you.
Your Honor, we do have a plea resolution to put on the record today. Hopefully the plea form is in front of Your Honor.
It is. What's he pleading? Is this guilty?
Guilty, Your Honor.
Certainly. All right. I have here that the defendant will be pleading guilty to count 2, attempted resisting and obstructing a police officer. That's a 1-year offense. Also count 3, operating while visibly impaired, the 93-day offense. Upon a successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Salvatore Lorenzo.
All right. Sir, it is this court's understanding that you are going to be pleading to 2 misdemeanor charges. The first being the stated count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Also, that you'll be pleading guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a
Yes, Your
$300
Honor.
fine. Up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving the rights on that form as well as particularly the rights contained under paragraph 5 of your trial rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2024, at the location of Packard near Oakdale Drive, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had several drinks. It was 8 months ago. I had too much to operate a vehicle.
All right, were you stopped by the police?
Yes, Your Honor.
Why'd they stop you?
I had a flat tire. I was driving on a flat tire.
You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital?
Yes, Your Honor.
Was there a blood draw?
Yes, Your Honor.
Were the results of that blood draw 0.168?
Yes, Your Honor.
Do you have any reason to dispute those test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
When you came into contact with the police, what happened with your interaction with the police?
It was a poor interaction. I deeply regret it. I wish I would just have complied.
Okay, so what'd you do?
I was brought to the vehicle and I didn't put my leg inside the vehicle to be taken to the jail.
So they were asking you to get into the vehicle. They were arresting you.
Correct. Yeah. And I didn't.
And you just didn't put your legs in and tried to basically not get in the vehicle when you were ordered to get into the vehicle.
Yes, Your Honor.
Sir, if I accept your plea, you do understand that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct is defined under the Michigan court rules, that you would not be entitled to withdraw your plea, and any sentence evaluation the court would no longer be bound by. You understand that?
Yes, Your Honor.
Counsel, have there been any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept the defendant's plea?
I do believe the court is compliant with the court rule, but I would note for the record, that was not the only way in which the defendant resisted police officers that night. There was significantly more.
Significantly more? Like what?
Refusing to get out of the car, refusing all commands, refusing to get on the stretcher, refusing to put his body inside of the vehicle, refusing to let the vehicle doors be closed once he was put inside the police vehicle. I just think the court deserves the more accurate picture of what happened.
Is that correct, sir?
Yes, Your Honor.
Okay, I'm gonna just advise you one thing. Thank you, Ms. Feltes. That when you go talk to probation and when you're dealing with this court, you might as well be straightforward and truthful. Because if you're not, and I'm sure your counsel will advise you, bad things tend to happen. Are we understood?
Yes, Your Honor.
He wrote a very nice apology letter to the officers, Your Honor. He does feel quite bad about it.
Oh, I understand that. I'm sure he does. Usually when people get called to the table on something, they feel bad about it. I'm just saying he needs to be truthful and forthright with the court. Otherwise, that will be his second mistake.
Understood, Your Honor. Thank you.
Court.
And I apologize, I interrupted the ask if we were compliant, but I did thought the court needed to know.
All right.
Oh, yes, Your Honor.
All
Yeah,
right.
compliant.
Court will accept the defendant's plea. 2 counts, 2 and 3. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and victims impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond will continue. Do I have probation intake? All right. Sir, hold on the line. We're going to put you in with probation intake so we can start the process, okay?
Yes, Your Honor.
Thank you. Court does call the case, People versus Brian Maynard.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Maynard. Can you please state your name for the court?
Brian Maynard.
Thank you.
Your Honor, we're hoping for an adjournment to obtain and review the discovery in the case.
Objection, this matter will be adjourned November 5th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. There's one request if I could put in. Mr. Maynard is hoping to resume contact with the victim in the case. I'm guessing that I would probably need to speak with Ms. Landy offline about whether that's desired from the victim's side of things before the court can fully address it.
Right.
Okay.
My notes too would reflect no non-consensual contact disorder.
Yes.
Okay.
I think that, yes, that is what I would.
Understood. Thank you, Your Honor.
Thank you. Court calls the case, People versus Wayne Rankin.
Good morning. Again, Your Honor, Sam Bernstein with and on behalf of Mr. Rankin, who's approaching. Sir, could you please state your name for the court?
Wayne Rankin.
All right, thank you.
And then this, Your Honor, we put in a request for a proposed resolution from Ms. Feltes Landy, and we just need a little bit of time to get there.
He just reversed the names. See, this is what's confusing.
I meant to say Landy Feltes.
Said Feltes Landy. It's not it.
I'm in
Is
a
it?
transition stage myself here.
Are you? Okay, that's why we need the transitions. Got it.
There we go.
All right. So will November 5th be enough time for?
Certainly, Your Honor.
All right. I'll adjourn the matter November 5th, 2025, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Have a good vibe with you. Court calls the case, People versus Renee Darga.
Good morning, Your Honor. Patrick J. Politano on behalf of Renee Darga, and this is Felicia, her sister, who's her guardian.
Okay, very good. Your name, ma'am?
Renee Darga.
Thank you. All right.
You had his time and date set, I believe, initially for an arraignment. We would waive a further formal reading of the charges and maximum penalty. My client will stand mute and ask that Your Honor enter a not guilty plea on her behalf.
Pending having waived formal reading, standing mute, court will enter a not guilty plea. All right. And what are we doing?
Counsel, I'm just looking for a little bit of time to talk about the case. I apologize.
No, that's absolutely correct, Your Honor.
Just looking for some time, please, Your Honor, to discuss the case.
All right. So I'll adjourn the matter November 5th will work for you.
That will, Your Honor. Thank you.
November 5th, 2025, 9 AM. As to defendant's bond, I will set bond in an amount of $5,000 personal recognizance bond, no standard conditions, no assault behavior, possession of any weapons. There's to be no alcohol, recreational marijuana, or illegal drug use. I will also be consistent. Is it crystalline Rabago?
That is the name I have here.
Is there any reason she needs to have contact with her?
So Judge, she has moved to a new facility, but in the afternoons, they are all brought together just to work. So they would be in the same place, but I don't think that they would actually.
Gotcha. So, well, so that there's no confusion, I'll just order no assaultive behavior. I'm not gonna let people do, I'll let people do what they're gonna do.
Okay.
And if we have
Thank
to
you, Your
deal
Honor.
with it, we'll deal with it. All right. Thank you.
Thank you, Your Honor.
Take care, man.
Thank you, Your Honor.
Court calls the case, People versus Eric Hopkins.
Good morning, Your Honor. Robert Elman with and on behalf of Mr. Hopkins. Mr. Hopkins, can you please state your name for the record?
Eric Hopkins.
And in this case, people are gonna be filing a noli.
You are.
I am, but I haven't done it yet, but I will.
Okay. Any objection?
No, Your Honor, none at all.
I'll indicate at this time that the case is dismissed. McNally, I'll sign that when it comes through.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus George Walker.
And good morning again, Your Honor. Robert Elman with and on behalf of Mr. Walker, who I believe is present over Zoom. Mr. Walker, can you please unmute and state your name?
You have it?
George Walker.
Okay, I need a camera, sir.
I'm trying to get it to come up. It just keeps saying background.
Yeah, we just started using Zoom. I get it. All right, what do we? No, it's okay. You're there. I see you now.
My
Okay.
bad.
What are we doing?
Your Honor, after a conversation with Ms. Feltus, I believe we'll be asking for an adjournment. There's some additional information I think that the people need in order to make an offer and move the case forward.
That's correct, Your Honor.
November 19th, 2025, 9 AM, bond continued.
Thank you, Your Honor.
Did he say November 19th? I'm sorry.
Yes, sir.
Okay.
Really, man? Yes. November 19th.
Okay.
You got it?
Yeah.
Okay. And you'll know how to work Zoom if you appear that way, right?
Yeah, I got you, Judge.
Okay, all right. I'm just checking, making sure.
For sure.
All right, take care.
You too.
Court calls the case of the People versus Justin Kitara.
Good morning, Your Honor. Oscar Rodriguez with Justin Katere, who is on Zoom. Justin, can you give us your name?
Yes, Justin Katari.
Okay, thank you. All right, what are we doing?
Your Honor, we have a resolution in this case, and I hope there's a plea form in front of you there, as well as a police report. This is a no contest plea.
I don't
dismissing the
have
initial
I don't
charge.
have anything.
The materials were emailed to your office on October 8th, along with the plea form.
October 8th?
Yeah.
Probably.
I thought they just sent over as well.
What?
I thought they had gone over as well, so I'm just trying to see.
It's October 8th at 1:49 PM.
Well, even if we have one, is it gonna be a no contest plea?
I think it had to be due to lack of recollection, Your Honor.
Okay, because I don't recall reading all those police reports are sent to me. I don't recall receiving a police report, but we were on vacation and just coming back from vacation.
Yeah, I don't know, maybe my last name is spelled wrong. I don't see anything.
You don't see anything.
Oh, I don't. have-
I can re-forward that email.
You have it, Miss Lundy?
No, I thought I did, but now I see that what I had was the progress report that Ms. Widely had sent for this person. I was mistaken. I had sent the plea form to Mr. Rodriguez on the 6th. And he let me know that it would be entered, so I'm not quite sure what happened. I don't have a copy.
All right, so you don't have a copy of it signed. I don't have a copy. I don't know. Do I have his advice or rights? We don't have anything, so I'm gonna adjourn this out to November 5th, 2025. I've got 185 cases today. I'm not gonna stop to read a police report. Once we get everything, I'll take a look at it. Hopefully can take the plea on that day. Thank you. Court calls the case, People versus Charles Peters.
Good morning, Your Honor. James Bifelsky appearing on behalf of Mr. Peters, who's to my right. Please state your name.
Charles Peters.
I have before me a plea form that indicates the defendant's going to be pleading guilty to an added count 2 of operating while visibly impaired. Upon his plea to that charge, count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Right hand. Solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth.
I do.
State your name.
Charles Peters.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days jail, $300 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole?
I'm blowing into the pro link, but I believe that's a condition of bail, not probation or parole.
That is correct for this court.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes,
and because you believe that you are indeed guilty?
I do.
August 11th, 2024 at I-94 near State Street, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 3 IPAs. I only saw IPA on one of the cans, but I drank 3 of them and they were not shorts, they were talls. This started at about 2 in the afternoon and went until about 5 in the afternoon.
Were you stopped by the police or was there an accident?
I was stopped by the police. After I was stopped, there was a separate vehicle that was in an accident. It was distracting for both the officer and myself, but I was not in an accident.
Okay, so you got stopped by the police.
Yes, Your Honor.
Were you ultimately arrested?
I was.
Were you taken to the hospital or police station? Or
I was
both?
taken to St. Joseph's Hospital. And
Was there a
then-
blood test?
Yes, there was.
Were the results of that blood test a .153?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
The blood test, no. I'm sorry, Your Honor, no.
So you have no, I want to make it clear, you have no reason to dispute those blood test results.
I have no reason to dispute the blood test results. The blood test was ordered after a breathalyzer, for which there was not permission asked. But the results I don't dispute.
There was not what?
I was given a breathalyzer when I was pulled over, but the officer did not ask. But the results in themselves, I
Did
don't
not ask what?
to distribute a breathalyzer.
The one on the PBT?
Yes, Your Honor.
You've heard of implied consent?
Yes, Your Honor.
You know what that means?
Um,
That means for the privilege of driving on these roads and having a license in the state of Michigan, you consent to taking a PBT. You understand that?
yes, Your Honor.
I take it by your eyebrows that you didn't understand that, but you understand that now.
Yes, sir, I do.
All right, so you have any reason to dispute the blood test results at the hospital?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
It was.
Counsel, well, I do have to advise you, sir, that if I accept your plea and you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that you would not be entitled, or the court would not be bound by any sentence evaluation or recommendation. And also, you would not be entitled to withdraw your plea. You understand that?
I do, Your Honor.
All right. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to probate to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond continued. Thank you.
Your Honor, very briefly, my client has been assessed by Von Schwartz. It was last year, sometime shortly after the incident. But he's also, so I'll forward that to.
That's probably going to be stale. He's probably going to need a new evaluation.
My request is, would the court consider discontinuing the sober link at this point? My client has done about 45 AA meetings, has a sponsor, has really taken hold of the reality of the situation and made positive movement and no positive blows on the machine, I think for about 2.5 months.
Ms. Feltes, I know you want to say something. I'm just going to shortcut this. No.
Okay.
Thank you.
Thank you, Your Honor. Have a good day.
Yep, you too. Court calls the case People versus Flores Rivas.
And Crystal Marie Medina, Your Honor, good morning on behalf of Ms. Flores. Your Honor, my client does require the services of a Spanish interpreter. However, I am prepared to waive for the arraignment purposes, Your Honor. I speak Spanish fluently. I was able to go over all of her rights with her, and I do feel comfortable waiving formal reading and standing mute.
All right, I could do it in Spanish. Okay, no, I can't. I'm lying. I mean,
Nombre completo.
Dalia Flores Rivas.
Thank you. So as to the arraignment, counsel, you waive formal reading, your client stands mute.
Yes, we would, Your Honor. Thank you very much.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. You need a new date.
Yes, Your Honor, and we would ask if the court would be inclined to allow us to return on November 19th. I have multiple matters scheduled for November 5th, and we're hoping to work out a resolution prior to that date, Judge.
She wants the 19th because she's got other stuff to do. That's more important than coming here and seeing me.
No, Judge, I will make it
No,
work.
that's what Alan, is that what you're hearing? That's what I heard.
No, Judge. Previously scheduled.
All right. I'll adjourn it to November 19th, 2025 at 9 a.m. We'll have an interpreter available via Zoom.
Thank you very much, Your Honor. I do appreciate that.
And as to bond in this case, and I trust that you will also explain this to your client, I'm setting her bond at a $5,000 personal recognizance. I'll order standard conditions like no leaving the state, etc. No assault behavior or possession of any weapons.
No posesión de armas o darle golpes a nadie.
No alcohol, recreational marijuana, or any illegal drug.
Drogas, including marijuana. And not to return to Walmart, Your Honor. I believe it's.
Yes, she's not to enter any Walmart in the state.
Thank you. Y no entrar al Walmart. Ningún Walmart.
All right.
Thank you, Your Honor.
Thank you.
Thank you very much, Your Honor. It was a
Okay.
pleasure seeing you. Thank you.
Thank you. And counsel, Can council approach on this matter?
Yes, Your Honor, permítame.
Court does call the case People versus Alyssa Hatfield.
I should tell this to people.
Good morning, Your Honor. Tina Saxon. For Melissa Hatfield. Melissa, state your name.
Good morning, Melissa Hatfield.
Thank you.
Your Honor, I believe we're in receipt of all discoveries. So I'm asking for a final settlement conference
You want to do this Friday?
this Friday. Is that what you said?
I did, but
Um,
I don't think the people would be ready, but.
I'm not sure that I can be ready by Friday. I apologize.
All right, no, that's fine.
I was this close.
Jury final settlement conference will be set for December 5th.
Yes.
December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be the 8th,
Yes.
December 8th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Your Honor.
Bond will continue. Court calls the case of the People versus Reginald Sims.
I should tell this to people.
Take out my.
Your Honor, I did receive a stipend order from defense counsel requesting to adjourn this matter. I wasn't sure if it made it in before the deadline or not.
I don't think it did, but
We didn't get until yesterday afternoon.
we didn't get it till yesterday afternoon, but Miss Counsel's not here.
And I don't think I replied until yesterday afternoon. I didn't get it until Tuesday afternoon.
All right, Mr. Sims is here, however. Yes. All right, your counsel's filed a stipulation to adjourn this. It came in after the deadline, so it didn't get processed by us. What I will do, sir, is I'll adjourn, since you're here, I'll adjourn this matter to November 5th, 2025, 9 a.m. All right?
Thank you, Your Honor.
Thank you, sir.
Neither one of those facilities has signed in.
Court calls the case People versus Alejandro Cervantes.
Remember, this wasn't a arraignment, filed without.
Without counsel and the facility, we know that they're in custody or not,
Yes, confirmed, but they're not.
but the facility did not sign in. So I'll adjourn this to November 5th, 2025, 9 a.m.
Is that a federal, is it federal who represents? That is my understanding. Okay, thank you.
Court also then calls the case, Freyandes Martin.
Special focus for the people. This is also an arraignment. So we confirmed it did not sign it.
On both cases.
Yes, sir. Both.
So I'll adjourn both these matters to November 5th, 2025, 9 a.m.
Thank you, Your Honor.
We have our. That it for that block,
That's it for that.
and then we'll come up with our next block. The gentleman seated to the very back. What? Yeah, what's your name?
My name is John here,
And where are you from?
South Carolina.
Okay. Is he on our docket today?
You said the list is Eric. Yes, it's Mr. Nary, Your Honor, but he's not until at a later time block. Yes, we spoke
What?
yesterday.
Pardon?
Yes, and I spoke with Mr.
Council approach on that.
Pardon, Your Honor?
Yes. I don't probably need a form. Do we have it now?
Party, and I understand that he wants to accept the offer in which he would be pleading guilty in one case. The other case would be dismissed, and the one he's pleading guilty to would be a deferred sentence, if I understand the offer correctly.
That is the offer, Your Honor. I suggest he pleads in the more recent case, which would be 1090.
So he'd be pleading to the possession of drug paraphernalia.
Correct.
And I have no form on that, right?
That is correct, Your Honor. I did meet with Mr. Party yesterday morning, and he indicated he did not want to plead in my case at that time. I understand that there might have been a change in that.
So
My request in my case would be for then a brief adjournment, given that development, Your Honor.
Well, if he wants to plead, to the older case, I'm okay with that.
But
I
the
don't
problem
care.
is that he's indicated that he didn't want to plead in that.
In my case, correct, Your Honor.
I was confused on what was going on when I spoke with her. I didn't know. I just wanted to know, I hadn't spoken with my other attorney. So I just wanted to know what's happening in both cases before I made a choice. And
Okay.
after I'd spoke with her,
Is he held on anything other than this?
No, Your Honor. He's held on these two cases because of the remand on the bond violation.
Oh, I know. I know why he's here on my cases, but there was not anything else he's held on. All right. So what does he want to do? I mean,
I was gonna plead guilty on a case and I was hoping to be released.
all right. So we'll then have him plead in 621. And then the other one will be dismissed because of the conversation that he had with you, Ms. Payton. That way there's no. I'll probably need a form at some point, maybe not. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Andrew Party.
Sir, it is this court's understanding you're going to plead guilty to the charge of possession of drug paraphernalia under the Pittsfield Township Ordinance. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
Understanding that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind. Had you previously, yeah, that's a problem. Have you executed an advice of rights form?
He has not signed it, Your Honor. However, I did review it with him.
All right.
Would you like him to sign it now, Your Honor?
Yes.
I got a date. Oh,
You got that advice of rights form. You have any questions regarding any of those rights?
no,
You'll see on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights
yes, sir.
by entering this plea. Does anybody promise, you understand also you're giving up your right to appeal of right?
Yes, sir.
Anybody promised you, are you on probation or parole? I'm sorry.
No, sir.
You're not? Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, I am.
of your own free will
All free will.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Find my ticket in this case. On the date of May 18, 2025, at location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan. Did you have drug paraphernalia in your possession?
I believe I did. Yes, sir.
Did you have a syringe and used crack pipes in your possession, sir? On that date?
It was in the, it was in the car. Yes. Yes, Your Honor.
Okay, and were you in the car?
Yes, I was.
And were these items yours?
Yes, Your Honor. I guess.
Well,
That's complicated. I knew they were in the lug. I just knew they were in the luggage. I didn't take them out. So, but I knew they were there. So yes. Oh, I knew that was there. Yeah, same thing.
Yeah, Your Honor, if I can help clarify, one, because the case of Ms. Pate involves a car, the case that I represent him on involves a hotel room. So I think he was just confused on
Confused as
when
to
you
which
said
one.
car.
They're
On
both by
my,
the same area.
may I have a board hearing, Your Honor?
Yes, you may.
All right, so, in the hotel room, you had a bag or luggage with you,
Yeah, yeah.
and there was a syringe in your
Oh,
bag.
yeah. Yes,
Is
sir.
that correct, sir? Okay, and you knew it was there?
Yes,
All right. And you used that syringe for the purposes of taking narcotics of some type. Is that correct?
yes, Your Honor.
All right. Sir, I do have to advise you, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules. The court would not be bound by any sentence evaluation, and you would not be entitled to withdraw your plea. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your
No,
Honor.
Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
Yes,
You
Your
have,
Honor.
Your Honor.
All right. In case 621, court will accept the defendant's plea of guilty. In the other matter, that case is dismissed pursuant to the plea agreement.
Your Honor, I can file a nollie process if that would. Oh,
Yes, please.
all right, I will.
If you would.
Okay, I will.
Okay. And on this matter, I had revoked your bond. Anything you want to say before I do impose sentence, or you want me to set them for sentence?
I have people that are in my hotel room. I went out. I've been trying to get there with all my belongings, and my anxiety's been going through the roof. I don't know what they're doing with my belongings. I'm afraid they could all be gone, and everything I own is literally there. And I would do anything if I could get there to find out they're even in my hotel room still. I got stuff worth almost to $100,000. Like I got a brand new bike.
He's
Everything's
just trying to ask if Your Honor will release him today is where he's going with this.
Thank you.
I got a vehicle that's sitting at this hotel. I don't know if my vehicle's there anymore.
How long has he been in? He's been in.
Like 40 days, I believe. It's been over a month.
I believe it was since September 17th, Your Honor.
Yes, it is. I see it. It's 15. Fines and costs of $250. I'll make that due and payable by December 31st, 2025. 90 days of jail credit, 30 served, the balance is suspended.
Thank you, Your Honor.
Thank you.
Your Honor, do we need to address the bond violation? There's also,
There was a bond violation, but do you admit to the violation?
Yes, sir.
I'll sentence him to 30 days, credit 30 served on that.
thank you.
Your Honor.
All right, thank you. Yeah, can you have a hand wave? Court calls case People versus Sharon Abbott.
Ashley Phelps for the people.
Sherilyn Foster Tucker on behalf of Sharon Abbott.
Good morning, Your Honor.
Your name?
Sharon Abbott.
Thank you. What are we doing?
Your Honor, we're just asking for an adjournment. I'm hoping to give the prosecutor some information, so maybe a little bit longer of an adjournment if possible.
November 19, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Jacqueline Murray.
Ashley Phelps for the people.
Edward Drooks for Jacqueline Murray.
Jacqueline Murray.
Thank you. What are we doing?
Your Honor, I'm asking just for a brief adjournment.
November 5th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus Mutada Al-Khalaf.
Ashley Phelps for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. El Kalfa Murtada. Yes. Hold on. Take it down.
Can you state your name, please?
Marzada Alcala.
All right, you need to turn a camera on, please. All right, thank you.
Your Honor, we are requesting an adjournment. My client has
Go ahead.
an appointment at Secretary of State on Monday to
On Monday?
get his license. Yeah.
Oh, to get the whole license, you think?
Well, actually,
Or does he just starting a process?
I should clarify, yeah. Do you know if you're gonna be receiving your license on Monday or just they're gonna tell you what you need to do to clear it up? I can't remember. I apologize.
Give me some information on what I need to do.
They're gonna be giving you some information on how to get your license? Is that what's happening?
Yeah, so I'm just waiting
Okay.
on what they say.
November 19th, 2025, 9 AM. We'll try to figure out where he's at that point. Okay? Thank you.
Thank you.
Thank you, sir. Court calls the case, People versus Deanna Conrad.
Conrad Solar on behalf of Pittsfield Township.
And Ashley Feltus for the people.
Assistant Public Defender Natalie Pitkin on behalf of Ms. Conrad, who is approaching. Please state your name for the record, ma'am.
Deanna Conrad.
Thank you.
Thank you, Your Honor. Today's the date and time set for a pretrial hearing, and I'm also prepared to address the bond violation, if the court would prefer to start with that.
Yes, wait.
Thank you, Your Honor. So I did receive the violation report. I'm sure the court is in receipt of, where my client.
Go ahead.
My client did test positive or did consume alcohol while on bond.
Yes.
She admits that both to community corrections and to me, and she does admit bond violation today. When I did initially get this report and speak with Ms. Conrad regarding the violation, she was immediately forthcoming with me. I did then advise of the warrant, and then she did, under my advice, turn herself in on that warrant this morning. She does take full accountability of the fact that she did consume alcohol and does apologize to the court. She is asking if the court would consider releasing her today, given the fact, and she does recommit to her sobriety and acknowledges to me that she will not consume any further alcohol while on bond. This is a case from 2018. My client does have full-time employment. She works as an inspector for Real Truck, and she is hopeful.
But she didn't even, hold on. I mean, I'll listen to you. Really? That's like the 5th time.
I'm not rolling the next one.
What?
Here's for your honor.
No, I mean, bless you. That's not, I meant to say it that way. In this case, she was a 2.55 in a crash. And so while you're talking the time between when that has occurred and where we are now, that's fine, except that then she doesn't make it very long once the conditions are put in place and she's drinking.
She does admit that she drank while on bond, Your Honor, and does take full accountability for that and does apologize for that. It is my understanding, I can't make the representation for sure, but it's my understanding that since this alleged offense in 2018, that there has been no further similar type of conduct. I don't know that for a fact. That is my understanding. However, she does acknowledge that she did violate her bond in this way. I'm asking that she be released today. I believe her to be put on the scram tether, and that she can come back for an adjourned pre-trial date to prove her or show that she does take her compliance seriously to the court. She was always very honest and communicated with me and wanted to take full accountability for her actions. And she did turn herself in this morning on this warrant. And she is asking if the court would allow her to.
Right, but wasn't she on a scram before?
Well.
So, all right, I mean, I'll hear you out, counsel, but I don't know. Why would I release her under the same conditions when in very short order she had violated why would I do the same thing again?
I understand the court's concern, Your Honor. Ms. Conrad, this was a wake-up call getting this warrant. She takes it seriously and did turn herself.
It wasn't a wake-up call just being present in court telling you not to drink?
Your Honor, I believe this was a harsher wake-up call. And I would just ask if the court would consider letting her out and giving her a chance. And I completely understand if, and Ms. Conrad is fully aware, if she were to violate in any capacity again, in all likelihood, her bond would be revoked until the pendency or till the end of this case.
How did she
at the
get
very
here to
least.
turn herself in?
Pardon me? I don't, oh, how did she get here to turn herself in? I don't know for a fact.
Can I speak?
Where did you get here?
I'm sorry.
How did you get to the jail?
I was dropped off.
Oh,
My roommate.
Your Honor, her roommate dropped her off at the jail.
May I ask a question, Your Honor?
Sure.
The violation report the court is reviewing, is that dated, October the 4th?
I do have an October 4th report. That's the one that I'm looking at.
I was confused because when I review this, it says on the second page that the defendant denied alcohol consumption, it says he used cough syrup.
I know.
Okay, I'm sorry, I wanted to make
No.
sure, I had put it differently in court, so I was concerned that there was a revised report that I hadn't received.
Correct.
We'll let the court know as well, there was a 2010 prior offense, so this is at least the defendant's second.
That is correct, Your Honor. She admitted to her first violation of drinking a glass of brandy to community corrections, and then did admit to consuming cough syrup, which technically usually has alcohol in it, and they're provided at community corrections that they should not
Did she
consume.
really drink cough syrup?
Yes, she did.
You did?
Yes. Well, actually, it was Alka-Seltzer plus.
So what are we doing on the case?
I'm asking for an adjournment, Your Honor. My office has not yet received media discovery in this case. I have requested it from the people.
Both of her cases will be adjourned to November 5th, 2025, 9 AM. I'm just, so it's really two violations all at once. In essence, I mean, because it told her not to drink, she drank. Right? And then I guess presumably then has cough medicine that she can't have while she's on bond. And they go through, you hold your hands up like you didn't know that. They go through that with you. You can't have anything that has any alcohol.
I didn't know Alka-Seltzer plus.
Your Honor, we are not at all skirting the first violation at all, the alleged one, and Ms. Conrad states to community corrections and to me that she'd consumed liquor brandy on that day. My client is telling me that the report about the cough syrup allegation, and I understand what Your Honor is saying, and I do understand that community corrections provides that information. Ms. Conrad is now telling me it was Alka-Seltzer plus, and she did not know that that may have alcohol in it. But she does acknowledge that first violation, her very first one, and she was immediately honest with community corrections.
Yes.
In the water?
Yes.
That's not cough syrup.
Cold medicine. I said I took cold medicine.
Your Honor, my client is stating to me that
I questioned Ms. Conrad about the alcohol detection. She denies consuming any alcohol and states she used cough syrup.
Cold medicine.
Your Honor, my client.
So now you're saying you said something different that's in the report?
I'm saying I said cold medicine. I didn't say cough syrup. I said cold medicine.
So you're saying, but you denied consuming any alcohol, but now you're telling me that, huh?
I never denied consuming alcohol.
Your Honor, I believe
brandy-
she's referring to the brandy
Oh.
event that immediately she did admit that she had
Yes.
consumed liquor on that day.
She says. It says here, I questioned Ms. Conrad about alcohol detection. She denies consuming any alcohol. She states she used cough syrup. Where's her admission to the brandy?
On the first page, Your Honor, it states, I questioned Miss Conrad about this alcohol detection, and she admits to drinking a glass of.
On the, right.
That was after the first alleged violation. on
Right, and
September
then there's another one.
30th.
And so on that one, she says she wasn't drinking
Correct.
and that she had Alka-Seltzer Plus
That is correct, Your Honor.
or something in water that
Your Honor, ultimately, Miss Conrad completely acknowledges she drank brandy. And that
on
was
the
her-
one day.
Right.
But if here's the problem. If you're an addict and you're telling me on one day, yes, I did it because I got caught. But then comes the next time and you start going through what is the natural thing for most addicts,
Who
a
said-
denial. Saying that everybody got everything wrong. I didn't have any alcohol. It's coughs. I had Alka-Seltzer Plus. So you're saying Alka-Seltzer Plus came up as a positive?
I can't speak to that, Your Honor, but what
Oh,
I
I
can
can.
speak to is that Miss Conrad was enrolled on this in September 4th. She had a drinking event on September 30th. This was her first contact from Community Corrections about the drinking event, to which she immediately admitted to drinking liquor. She didn't try to make any excuses or say that it was cough syrup, cold medicine, or anything. She was 3 weeks into her bond, just shy of 3 weeks. She drank, she violated her bond. She takes full accountability to that with both the court as well as to Community Corrections. She did then have another event that the Scram Tether picked up on October 3rd. She states to me that she, yes, agrees with that part of the report, that she denied consuming any alcohol. She states to me that she told Community Corrections she took cold medicine. And of course, if that had any alcohol in it, she would not be allowed to do that as to bond, which she now understands. She does admit to drinking
But
while
she's
on
telling me it's Alka-Seltzer Plus.
As to the second event, yes, Your Honor, and she admits to the first one in complete
Okay, I'm
honesty.
gonna let you go ahead because I'm about so done. Right now.
She's taking accountability for the bond violation, Your Honor, and she's asking that the court
She's
release her
taking
today.
half accountability. She's not taking full accountability.
So if I say I drink alcohol, will it make a
So here's what I'm gonna do. I'm gonna adjourn this to November 5th, 2025, 9 AM for a sentence on her violation and pretrial. Her bond continues as denied. Thank you. Court calls the case, People versus Jeffrey Ostermiller.
Asheville, people. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Oscar Miller. What's your name, sir?
Jeffrey Ostermiller.
Thank you.
I am requesting an adjournment. Mr. Ostermiller got me a lot of mitigation materials of all the good stuff he's been doing. I just want some time to get that over to people.
November 19th, 2025, 9 AM. Bond continued. Court calls the case, People versus Devontae Connor Belcher.
Asheville, people. Does she have two cases?
I do.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Connor Belcher stands to my right. Please state your name for the record, sir.
Devontae Connor Belcher.
Thank you.
Thank you, Your Honor. I have two brief requests. One as to the pretrial, I'm asking for a brief adjournment. I had the opportunity to discuss these cases with Mr. Connor Belcher, and he has proposed a type of resolution that he would like me to speak further with the people regarding both of these. And I'd also like to briefly address bond when appropriate.
Adjourn both matters to November 5th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As of yesterday, the only matters holding Mr. Connor Belcher in the Washtenaw County Jail are these two matters. These are both retail frauds, and the bonds are currently set at 1,010%, as well as a third matter, which is disorderly out of 15th District, that the bond is currently set at 1,010%. I still need to contact the public defenders in that court regarding the
People
bond, but
gonna have any objection to a PR bond?
Leave it discussion of court.
so that's
Yeah, anything else you'd want to say?
No.
Good. Bond will be reduced. $2,500 personal recognizance bond. Don't mess it up.
Yes.
Hey, come back when you're supposed to. You hear me?
Sir, of course.
All right. Thank you.
Thank you, Your Honor.
He doesn't show back up. I'm taking you in, Pete. Shondell Barrett.
Good morning.
What was the name? Oh, Barrett, Ashley Feldes for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Barrett.
Ms. Barrett, can you state your name and turn on your camera, please? All right, well, she works on getting her camera on. Oh. Bless you. All right, I don't know what's going on.
Well, Your Honor, we are requesting an adjournment for plea negotiations.
Adjourn this matter to November 19, 2025, 9 a.m. Bond continued. Thank you, Ms. Barrett. When you come back on the 19th, know how to work your camera. Court calls case People versus Ishmael Davis.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Davis. State your name for the record, sir.
Ishmael Alexander Davis.
All right, what are we doing?
Your Honor, I guess two requests. The first is an adjournment of the pretrial as I am, we are in negotiations. And the second is in order to release Mr. Davis to treatment.
The
Mr.
court will
Davis,
sign that order if,
I do have it's non-stipulated. I don't want to speak with Ms. Feltes. She said she'd leave it in the court's discretion. I don't.
all right, then I'll sign the order.
Okay.
I'll grant your motion. Adjourn this to November 5th, 2025, 9 a.m. And I've signed the order for release to treat inpatient treatment.
Thank you, Your Honor.
Thank you. Oh, okay. Court calls the case People versus John Neary.
Ashley Feldes for the people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Neary, who stands to my right. Please state your name for the record, sir.
John Neary.
Thank you, Your Honor. Make the prosecutor and I approach.
Okay.
Thank you, Your Honor.
Mr. Neary wants to get out to a blind, so I'm just.
I don't drink. I don't.
Why?
So it's sponsored this happened surgery on the 27th of this month.
Oh, I'm
So
sorry.
it's gonna have a-
Seven. Our record should reflect we had a bench conference in this case. I'm going to, counsel's explained to me some things, Mr. Neary, and just with you and your family the best, okay, sir?
Yes, sir. I appreciate it.
I'll adjourn this to January 7th, 2026
Yes, sir.
at 9 a.m. And the reason I remember you remember our last interaction when you first came in, Mr. Neer?
Yes, sir. I was
You
I was on
remember?
the deer hunt.
Uh-huh.
Yes.
No, you
No,
were,
no.
I didn't know what you were gonna do. You were like kind of angry and just telling me you were a hunter, and I'm like, okay, I
No,
get it.
no, no.
No, I get it.
I'm not
You,
hungry.
yo, you started out. Hold on. No, I remember because when I saw you, out of
Oh,
all those people,
I trimmed my beard.
yeah,
I trimmed my beard.
yes, you did. But I recognized you. I said, that's him. That's
Yes, sir.
And so I was trying to figure out a way I was gonna do this, and then it was bow season, and I said, okay, we're gonna let him shoot with bow. And
Yes,
then
sir.
I remember the only thing that calmed you down was me telling you were coming back on the opening of firearm season, and I'd address it then. And you said,
Yeah,
okay.
Yeah. I won't be doing it this year though. I mean, I've got prior.
Well, yeah, and I understand why, and again,
Yes, sir.
be in our thoughts and prayers, all right, sir?
Yes, sir. Thank you.
What I am gonna do is, and I know you got more important things to take care of, but because sometimes while you're doing that, you may need a break. All right, and maybe you won't, but maybe you do. So what I am gonna permit is, I'm gonna permit him to possess a firearm in case he just wants to go out and just maybe clear his head.
My wife's more important though.
What?
The wife's more important.
Oh, I know,
That's what I
but
gotta do.
sometimes maybe you just need.
Mentally, yes, sir. I understand.
So
that.
I'm
Mentally,
just,
yes.
you don't have to do it, I'm just allowing it.
Yes, sir.
Okay.
I deeply appreciate it. I really
All
do.
right.
Thank you so much.
You take
Thank you,
care of
sir.
yourself and,
Okay.
give your wife my best, I haven't met her, but.
I will do it. I will do it. Thank you,
All right,
sir.
Thank you, Your
very
Honor.
much.
Court calls the case, People versus Taylor Meyer.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Mayor. Please court your honor. Attorney Damian Caspi, number 85852 on behalf of Mr. Taylor Meyer. Just on my right.
Your name?
Taylor Meyer.
All right, what are we doing?
And here we are here for a pretrial and a bond violation. To the bond violation, he pleads guilty to the.
He'd admit to the bond violation.
He admits to the bond violation, Your Honor.
Is
And
that correct, sir?
Yes, Your
You don't want a hearing?
no hearing, that's it.
All right. All right. Go ahead, what are we doing as to?
And to the pretrial, we've been presented an offer. And we would like to accept if the prosecutor needs to place it on the record.
Your
Well,
Honor, it's just my understanding that he's gonna plead guilty. I've approved him for a deferred sentence, and then that's the agreement.
all right, we need to make sure to get plea forms in because I don't know.
I will submit the plea form to the court afterwards with Mr. Cash's signature, or we can adjourn it.
I get permission to
Is he
sign.
being held on anything else?
Nothing else, Your Honor. And as I would ask for a release, his brother has been notified to come pick him up if he's released today. If not, obviously to the discretion of the court.
Why were you missing your test?
Why were you missing the test?
I was in Traverse City.
So how am I gonna make sure if I release you that you're gonna test?
I will go to the one that I was able to go to. And
Has he signed an advice? Never mind, sir. Have you signed an advice or rights form?
He's been tendered his vice versa. I was just presented it.
Well, I'm not gonna rush this. I'll take the plea, but I'm not gonna do it today. I need the form. I need this stuff done as I've asked it to be done. So I need the form, his vice rights form, and everything to the court, and I'll be more than happy to take his plea. I'm adjourning this out to my next date of November 5th.
November 5th.
Mr. Cash, I'll email you the form tomorrow.
2005, 9 a.m. to start down that path, and I just don't get the paperwork that I need. Bond, continue. Thank you. Court calls the case, People versus Shadira Akiji.
He's in custody. Without just.
Oh, we're just down to the, okay, gotcha. If you want to throw some of the 11s in here, I could just start on those. I may not be able to get through them all, but whatever one. Because otherwise people will be waiting for these.
Mr. Stiller, this is your case, I think. It's EKG.
Thank you. Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. EKG. State your name for the record, sir.
Chidera Bennett, the cage.
All right.
Oh.
What are we doing?
Trying to get it right. We're asking for an adjournment, Your Honor. This is a no registration case. We believe the car has been sold, so I just need time to get that from Mr. EKG's family to Mr. Stiller.
November 5th, 2025, 9 AM, bond continued.
Thank you.
Court calls the case, People versus Kurt, is it Bushland?
That's both for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Bushlane, who is present via Zoom. Sir, can you please state your name for the court?
Oh, yes, Craig James, Bushline.
All right, what are we doing?
Thank you, Your Honor. I have had the opportunity to discuss this case with my client, and at this time, we're asking to set the case for final settlement conference.
Jury final settlement conference will be December 5th, 2025, 9 AM. Jury selection if necessary, December 8th, 2025, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Bushlane.
Yes, ma'am. Do I get a letter from you?
Court calls the cases of the People versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
That's both for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Lester. State your name for the record, sir.
Paris Lester.
You know, we're close to a resolution. We're just need to nail out some details. So I'd ask for an adjournment. I think that this should be fine. Mr. Lester is being held on a sentence for the next couple of months.
November 5th, 2025, 9 AM on all.
Thank you.
Thank you, bond continued. Court calls the case, People versus Brandon Nash.
That's both for the people.
Your name, sir?
Brandon Nash.
Good morning, Your Honor. My name is Sam Fisk, and this is my partner, Melanie Lemus. We're student attorneys with the University of Michigan.
You're kidding.
We are not.
You're kidding. I'm shocked. They're student attorneys, Alan. No, go ahead.
We are requesting permission to practice under MCR 8.120 under the supervision of Sarah Sal.
Good morning, Mr. Allen. So, hold on. You haven't spoken before?
Not
You
yet.
did all the talking, right?
Yeah.
Why?
He was in class.
Is he? Oh, he was in class?
And he was scared.
Oh, that's not what she said to me. She said you were gonna mess it up. Okay, that's why he's not here. Where are you from, young man?
I grew up in Hartford, Connecticut, sir.
Connecticut?
Yeah.
Where'd you go to undergrad?
I went to Claremont Mechanic College, Your Honor.
Where the hell is that? I mean, where's that?
California, Your Honor.
So you left Connecticut, went to California,
Yes, sir.
and now you're here.
Yeah, I lived abroad for a year and now I'm here. So I took the scenic route.
Lived abroad where?
I was at the University of Cambridge, Your Honor.
Oh, excuse us. You see that? How he just threw that up in there. I was abroad. He wasn't going to say why.
Candor with the court, Your Honor.
No, that was good. So he went to Cambridge. He started in Connecticut, went to Cambridge. Well, then California. And now you're here. So when you're done, you're not going to stay here.
I'm going back to California, Your Honor.
So why don't you just go out there?
I got into Michigan, Your Honor.
That's not a big deal. Anyway. Speaking as a Maryland grad. All right, permission to practice is granted. I'll let you go ahead.
Thank you, Your Honor.
On behalf of your partner, don't mess this up.
Fingers crossed, Your Honor. This morning, we're seeking an adjournment.
Yes, go ahead. Why?
Well, we're still waiting on discovery in a case with a common nucleus of facts. So we're waiting to hear from the
What?
other
Did
attorneys
he
in
do
that
some
case.
Latin there? What'd you say?
From a very related case, we're still waiting on discovery.
What? No, what word did you use?
Common nucleus of facts.
Garen, did you know what he meant?
I couldn't understand what
Yeah, I didn't get it. He might as well have done it in French because I wouldn't have understood what he was talking about. Oh, so common nucleus. It's like I'm in a science class. All right, fine. So you're waiting on discovery on that?
Yes, Your Honor.
From where?
From the attorney related in the felony matter.
Oh. Is it the public defender that's representing him on the felony?
I believe so, Your Honor.
No? He got it wrong.
Oh,
He got
okay.
it wrong.
Apologies.
See,
Yeah.
selling back there. So you're just waiting to get some information?
That's correct.
Okay, so how much time would you need? She is so thankful she's not up today. How much time did you need?
We would be interested in working towards the final settlement in December, if that's possible. We believe the next one is on Friday or so, and we think that the final settlement in December is appropriate.
Wow. South, is there anything you want to say on this?
If we are hoping to resolve these matters short of trial, I would recommend adjourning retrial rather than proceed to final settlement conference.
So what do you want to do? Don't look at her. You're up. She had to do it on her by herself and did a fine job.
We believe a 2-week adjournment would be appropriate.
So you can do it by November 5th? Or do you want November 19th?
More time would be better, Your Honor. So November 19th.
No, you don't even know that. Miss Sullivan, what day would you be available? It was the 5th or the 19th. Boy, oh boy, he's just, you want to know why it's that Cambridge education?
Your Honor, the 19th would be preferable.
Thank you. Will that work with you?
Yes, Your Honor. Thank you.
Of course, you're a student. You're not doing anything.
Yeah.
Mr. Nash, don't get nervous. You're in good hands. You good?
I like you.
Huh?
I like you.
Him?
Love the sense of humor. You.
Oh, me?
Yeah.
Oh, yeah, I like me too. What do you think about him? No, don't say it.
Your Honor, additionally, we'd like to request a Zoom proceeding if possible. Brandon has to travel 2 hours from Kalamazoo for these proceedings. And it'd be easier for him if we could do it remotely.
Okay, we all know how that's done.
If I may, Your Honor, you wanted him to be present in court?
That is correct. So, but I think that was because of his testing.
That's right.
And I'm a little bit worried about that. I'll get to that. November 19th, 2025, 9 a.m. as your invite indicates. I'll adjourn it to that date. Do I have new test? I have October 8th. He's got results pending on his ETG. Do you have a medical marijuana card?
No, sir.
And why do I have THC in your system?
Your Honor, honestly, I was a heavy smoker, but when you said don't smoke no more, I did not smoke. I was calling the drop line every day and my levels have been coming down.
It's London.
The defendant is on parole.
Got it. That's right.
We had come, I think the court calls out, we had come and we had talked about him being an absconder at the time that he picked up 2 retail frauds in Washtenaw County. And the court very graciously has given him PRs in this case, as well as the felony, which is not before the court today, But that's a great concern to the people.
But my understanding is he was on it, but I thought his absconder status, he's rectified
That
that
is
issue.
correct. That is correct, but I still think he's on parole at this time.
Is that correct? You're still on parole?
Yes,
And you can't use while you're on parole.
honestly, they don't test for marijuana on parole. But when you told me to stop smoking, I stopped. And my levels came down, like you said, last via Zoom, and I'm just on the right path, honestly.
All right. If you submit the proper paperwork, I'll allow a Zoom proceeding, provided I don't get a positive test. If I get a positive test, you're gonna need to be here. Understood?
Yes, sir.
All right. Anything else?
No, Your Honor, thank you.
Sure.
Positive.
Is there anything else? Or is, no, I'm asking you. Because you know what's going on. Is there anything else?
No.
Is he good?
He's
All right,
good.
we're good. All right, thank
Thank
you.
you.
Tom, continue. Oh, that's okay. He's from Cambridge. Court calls, don't talk to him. Court calls the case, People versus Christopher Minor.
Conrad Solar on
Okay.
behalf of Pittsfield Township.
Kara didn't step anywhere near that. I don't know what that.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Minor. Mr. Minor, state your name, sir.
Christopher Minor. Thank you.
Your Honor, Mr. Minor would like to set this case for final settlement conference.
All of these?
Oh, yeah.
What? What was that?
Well, I forgot that there were Mr. Siller's cases, to be frank. No offense, Mr. Siller. I think, actually, can we ask for one more adjournment? We'll resolve Mr. Siller's cases, and if Mr. Minor still wants to set the state case, we can set it at that time.
Okay,
Does that make sense?
well, I understood you. Whether or not it makes sense or not. I'll adjourn everything to November 19th, 2025, 9 AM. I'm presuming he's held on something other than me.
Yes, he's being held on his probation violations at Judge Hamoud's court.
All right. Is there a hearing on that setting time soon?
Do you know when you're gonna see Judge Hamoud again?
That's okay.
Yeah.
I'll just adjourn it out to the 19th. And then we'll go from there. And if it's bond changes on that, certainly you know how to get in touch with the court. Thank you.
It looks like the 3rd and the 11th and the 3rd, no, the 16th and the 3rd, so.
Got it. Okay. Court calls case People versus Eric Burton.
People.
Good morning, Judge Kyle Brunel on behalf of Mr. Burton, who's approaching the podium. Mr. Burton, please introduce yourself to the court.
Good morning, sir. My name is Eric Burton.
Thank you.
Your Honor, today's the date and time set for pretrial. We are asking that the matter be set for final settlement conference.
Jury final settlement conference, December 5th, 2025.
Thanks, Judge.
Was that Perry again? Bless you, whoever that was. Oh, that was you? Man, that was loud. No, I'm just kidding. December 5th, 9 AM, jury selection if necessary, December 8th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Thank you. Have a good day. Court calls the case of the People versus Robert Moyle.
Conrad Solar on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Mr. Robert Moyle, stands to my right. Please state your name for the record, sir.
Robert Moyle.
Thank you.
Thank you, Your Honor. I'm asking for an adjournment of this matter. Mr. Moyle is serving a sentence and being held until April of next year. I did speak with him regarding this matter, and I need to contact a nephew of his to obtain some potential documentation.
You know what? Given that, if he wants to admit double parking today, he can do that.
Oh, then I think you would want to do that because that was what we were going to be doing with the documentation. So
Right.
Was that something you want to do today instead of at the adjourned date, Mr. Moyle?
If we want to take care of it today, let's do it.
Perfect.
Is that what he wants to do?
Yes,
So, Your
sir.
Honor, I moved to add count 2 of double parking. You accept that admission, move to dismiss the original charge.
Absolutely.
And so, sir, do you admit responsibility to the fact that on February 20th, 2025, location of Washington Avenue in Pittsfield Township, that you double parked the motor vehicle?
Absolutely, sir.
All right, court will accept that admission. The double parking count 2, count 1 is dismissed. Fines and cost in the amount of $180. That will be payable 90 days after release.
Thank you.
All right, thank you.
Thank you, Your Honor.
Court does call the case of the people versus Michael DeWitt.
I should call this for the people.
Morning, Your Honor. Dan Garrett on behalf of Mr. DeWitt. Can you-
Michael DeWitt.
Your Honor, for arraignment, we would waive reading and stand mute, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
Another pretrial date, Your Honor. I still have not gotten discovery.
All right. 5th or 19th.
19th, please, Your Honor.
Turn this matter to November 19th, 2025. 9 AM. As to found in this case, I will. I think it's. You may want to make sure you get your appearance in. I don't know why it's not appearing, but.
Yeah, we just filed it yesterday, so it may be lag
All
time.
right, that may be why. Set his bond at a $5,000. Personal with cognizance. Order standard conditions, including no assaultive behavior, possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. Any reason you need to have contact with Joshua Wade?
No, sir.
I order no contact with Joshua Wade. All right. I trying to figure out, is it,
We did not request a no-go to your,
that was because it was at Costco. Right.
I'm sorry.
There's a no-go to, but the event occurred at Costco. So
He did, we didn't ask for a no-go to
That-
Costco, but the court.
Well, I'm not gonna necessarily order that unless it's connected to that. It seems.
You order my wife not to go to Costco?
What?
You order my wife not to go to Costco?
You know what? I'm not even getting into that
All right,
conversation.
sure.
No, she should. Okay, no, you see, you brought me into it. She gets to go all the time.
Well, I'm gonna work till I'm 90.
And to your lovely wife, spend as much money as you want.
Uh-huh, she does.
Wow. Wow, Darren. Wow.
Thank you, Your Honor. Have a good day.
No, you're in trouble yourself.
Oh.
None of,
Hopefully
all
she
of
doesn't
us are
watch-
sticking up for her.
Yeah, I bet
You
you-
are alone in this.
Have a good day, Your Honor.
Thank you. Thank you, sir. Court calls the case, people versus Thomas Sharon. Wow, Darren.
Also Wilford from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor.
We have 37 days of jail time credit, $250 in reimbursements. Does that sound right to everybody?
Yes, Your Honor.
That is correct. It's $250 on each case.
All right. Mr. Harris, anything additional from the state?
Your Honor, nothing, well, other than the fact that we did attempt to get a restitution figure through the victim. We've made several attempts at calls, victim advocate and even myself today, and we've been unsuccessful in getting any feedback on that. So at this point, we're unclear as to restitution.
Also Williford, anything from probation?
Nothing further, Your Honor.
Ms. Hinkle?
Thank you, Your Honor. My client's 134 days clean. She has been participating in the Genesis program. She's supposed to graduate in about 2 weeks, where she'll be transitioning to sober living at Full Circle in Fairfield, doing their IOP program. Like I said, she's had all clean drug screens. She's been compliant with pretrial. She's been doing the substance and mental health treatment. And so I would just ask that you take all that into consideration for sentencing.
Anything you want to tell me, Ms. Phillips?
That I'm remorseful in what I did, and it should have never happened. I'm free and clear. My head is uncloudy now, and I apologize.
All right, I am going to put you into my community control program. I'm going to do that for a period of 3 years. I'm going to impose upon you the standard rules of community control that will get to your officer the ability to make special or additional conditions as they see fit. Right now, it's a special condition of your community control that you enter into and successfully complete your treatment. This is at Genesis, and then the follow-up, if we're going to go to full circle with their PHB or whatever, that's a good plan. Follow through is important, so we need to stay on that. Makes sense for you to complete the court's thinking for a change program and ultimately get a job when you get far enough along in the treatment. We have $500 in reimbursements. I'm not going to impose a fine. I am going to impose the costs. There is no restitution. If you violate the terms of your supervision or you leave the state without permission, we can sentence you to up to 12 months in prison on each of these charges, plus the optional period of post-release control. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you, Ms. Phillips.
Thank you.
Thank you, Your Honor.
Thank you.
The State of Ohio versus Michael Brooks. This is case number 25 CR 42959. Present before the court is Mr. Brooks, represented by Mr. Moss, and we have Mr. Harris from the prosecutor's office. We are here today for a pretrial. Mr. Harris, what's our status?
Your Honor, we had extended an offer indicating that if the defendant pled guilty to count 1 of the indictment, which was illegal conveyance, we would agree to dismiss counts 2 and 3. Also, the offer would entail an agreement as to recommended sentence of 9 months consecutive to the time he's currently serving in prison.
Mr. Moss, what's our status?
I conveyed that offer to him. We only had a moment to talk, but he did not accept the offer. I don't think he actually turned it down either. I think he probably needs more time to think about it, unless he's changed his mind since we last talked.
Okay, Mr. Brooks, Mr. Moss said that you wanted to talk to me about something. What's going on?
For the record, I'm a beneficiary of the trust, and I'm appointing you, Your Honor, Judge, Mr. Donald, to be my trustee and discharge this matter. I'm requesting a redress in the amount of $500 for pain and suffering and time spent in this agency. For the record, I am not, I am I'm a man of God's creation. I have not contracted, nor do I wish to contract with this agency. For the record, I wish to see the bond agreement and the contract used to force me here to appear to this court today. Sorry.
So here's where we're at, Mr. Brooks. First of all, this is not a civil proceeding. This is a criminal proceeding. I'm not going to be appointed as a beneficiary or a trustee or any of that kind of nonsense. I don't need your permission to go forward with a trial in this case. I don't need a contract from you. You don't need to engage in any type of contract with the state of Ohio in order to be bound by the laws of the state of Ohio. So with regard to those issues, we're really not going to get very far on that. The state has extended an offer to basically allow you to plead as charged. We'll call it an offer. It's really not. It's you pleading guilty to the things that you were indicted of. If you want to do that, I will sentence you to 9 months consecutive to the time that you're already doing. For somebody who is doing an extended period of time in incarceration like yourself, probably more important than the 9 months is the fact that I will also make a finding that you are indigent for the purposes of fines and costs. There won't be any financial sanctions. Nobody's going to come after your commissary money for the next 50 some years. Alternatively, if you don't want to enter a plea of guilty to this charge, you don't have to. We'll just set it for trial. We'll let a jury decide whether or not Mr. Harris is able to prove beyond a reasonable doubt that you did this. If you want more time to think about it, you can also do that. We can set it for another pretrial in a month or so, whatever you want to do.
So, pleading guilty to the 9 months, what do they consist of? Because they got me like in prison. They got me under all type of restrictions and stuff behind us. But what I'm saying is, They restricted her from coming to see me. She didn't like, I had that stuff on. I never heard her get in trouble with it. You know, like, or. But at this point, if he pled. I'm saying with that, okay. It's up to the person that he wouldn't be able to do anything regarding. No. I'm saying if I plead. So, but now, with that, would she still be in trouble? Yes, but based on the current offer, if you pled, she'd still be facing her indictment. She's indicted on the same charge. So if you want, we can talk more about that, but we have to continue the case. So you're saying she still be? She's charged also. She got a court date. Anything to do with? Yeah. Well, that's what we have to talk more about that and talk to the prosecutor. But currently at this point, she's got a court date, I think, on Friday. Well, wait. I haven't heard of the prosecutor. It's like she never had anything to do with this stuff. I mean, I would something else, me personally. Only if she like, because she really never had nothing. Okay. I can. I think we will need more time. What he wants to do is, I'd have to talk to the prosecutor off the record. So we can't resolve it today. I mean,
All right. Also, one other thing that you should know, Mr.
I'll tell him. Okay. Yeah, I'm saying. Sorry, Judge.
One other thing that you should know, Mr. Brooks, is we'll set it for another pretrial, give you some time to think about this. It doesn't get any worse for you. This offer is not going to change. If you want to set it for another pretrial, the status of things is not going to change. So it's not like, oh, if you don't decide today, it's going to get worse. It doesn't work like that.
Right. One thing was, I just wanted to, I really want to, like, if don't admit the offense. No, I'm not doing that. Okay. But don't even say what she did or does that mean? Oh, okay. So, but I'll talk to him about that. Okay.
Okay?
Yep.
All right. We'll see you a month or so.
Okay. I'll talk to him right now. All right.
All right. We're in recess.
It would, if it were me, I'd consider it real important. What are you doing today?
Just move it to the announcement. This is initial appearance. But I have given him his indictment and police report.
Do I?
Said I have given him his indictment and the probable cause affidavit. He has all that.
All right, state, who is on this one, please? It looks like Mr. Laird.
Yes.
What is his bond here, please? You've already been convicted of two other felonies. Then you pick up, you've got a felon in possession of a firearm conviction in 19. Then here, I'm looking at the facts on this case, and there was a firearm used in this case. What's his bond?
Yeah.
Okay. I don't want you,
$35,000.
you're gonna have you're at home confinement. I don't want you leaving your home. And you have to have a GPS device, so I know where you are at all times. You understand? You don't like it? You don't like it? Tough. You are a danger. This is the third time you've messed with a felony. And you think it's other people's fault? You're gonna be at home confinement? Do you work somewhere?
No, sir.
You don't? Well, okay, then you don't have to be going to work. You can, who lives with you at the house?
Got my kids,
Mhm. Well, who supports the family?
my girl.
Who does? Your wife?
Sir, I just got back.
What, your wife supports the family?
Yes, sir, but
What does she do for a living?
She great. I just came back.
What does she do for a living, sir?
She's a general manager, sir. I just lost my job.
Okay. Well, you can go out and look for jobs, but you got to stay on home confinement. You can go find a job and you have to go to and from the job location in the most direct route. I got a lot of people who are on the same type of conditions and they are doing just fine and making a living. So don't say you can't do it unless you don't want to, but that's your condition. You are dangerous. I'm looking at the circumstances on this case. I don't want you ambling about without me making sure I know where you are at all times. You understand, sir?
Sir,
You've got 48 hours to get that done. All right.
Can I ask you something? You said it's three of them?
You have a conviction of being a felon in possession of a firearm in 2019, which means you had a felony
No, sir,
before that.
I was with somebody else, sir. It was two guns in the car.
Wait,
They took out running. So they
Felon in
both of us.
A felon in possession of a firearm.
Yes, sir.
That means you had to have had a felony. I mean, that's.
You did a jury trial on the felon in possession and got a guilty verdict. And they sentenced him 2 years.
Okay. He wasn't eligible for probation. That means you got a felony conviction.
Yeah, he's got state jail.
A state jail. Okay. What were you trying to tell me? That wasn't right at all, what you just told me.
No,
And you
sir,
know
that's-
more about your life than
That's
you
what
have
it-
you have a state jail felony conviction. That's a felony.
Sir, I was already a felon. I was already a felon, but the guy who I was with that took out running, that's what made it a felon in possession of a firearm.
I'm sorry,
because
the
it was
jury
two
thought
guns.
otherwise. They convicted.
Yes, sir. It was beat at first, but it was dead out, but they came back.
The jury, well, we have to follow the jury's verdict unless you appealed it and you didn't. And now we've got this situation. But you can go to and from work, to and from to get food, and to and from church. And we need to know where you are at all times, though, because I don't want you ambling about because you misuse firearms. What do you want to do next?
Just the announcement, Judge.
Okay, 4 weeks. Good.
Yes, sir.
Thank you. Please get a reset. Thank you. Serenity Mays.
He's here.
God bless you. Serenity Mays. please.
That's Miss Mays.
That's you? You're in 25 CR 967. You were charged with the 3rd-degree felony of forgery.
Yes, ma'am.
And that means you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. So it's serious.
No, the probation officer there.
Okay. Today, what do you want to do?
Yes.
Just, this is our first announcement, Judge. Just put it on announcement. And
4 weeks gonna be good or 5? Is that good? Okay.
you know,
All right. Thank you. Please get it resetting. Renisha, are these all initials? Renisha Owens. Renisha Owens, please.
I'll send it.
And cause number is 251035. Renisha Owens. There is no answer.
She's here. Come on up.
You gotta move quick. We got a lot to do.
Because you defer restitution. I won't give a fine. I'll cut this phone.
You gonna send it? I mean,
Okay, you're Renisha Owens.
Yes.
You're charged with the 2nd-degree felony of burglary of a habitation, which means you are looking at no less than 2 no more than 20 years confinement in prison, and a fine to $10,000 can be assessed. You understand what you're charged with in the punishment range here?
Yes.
And Mr. Adams is your attorney. It's an initial. What do you want to do?
just announcement.
Okay. Okay. 4 weeks good.
That's what
You're resetting
And Judge,
and
so,
follow his advice.
and Judge, on that deal, Damon, I have it at 9:30. He's in TDC, so it's nothing.
Okay.
Yeah, he's in TDC jail.
Okay.
And I verified that with Miss Lynn.
Okay. How would she? Who's?
Lacey verified.
How does she know?
I asked her.
Oh, she saw him there, I guess.
I-
Jacorin White,
BBC roster.
you were at Jacorin White, 25 CR 115A.
Is that it?
Come on in. Jacorin is wearing white today. What's the deal? I didn't get the memo on this. I'm underdressed.
Looks good.
Everybody else? I mean, well, it's nice that you feel this is important because it is.
It is.
You were charged here, sir. Hold on. You're Jacorin White. And you are charged here in 25 CR 1158 with the second degree felony of assault on a peace officer. Where'd he go? John, where's your attorney?
Oh, he has John West. John West texted me this morning and he said that he's stuck in another court, but he's asking for resetting term announcement.
Okay. When's he going to be here in this court? And which court is more important? I'd like to know. There's not a higher felony court than this one. I don't understand.
He's in another county, Judge.
Okay.
But
Did you know he wasn't going to be here? Have you met him before, sir? Okay. Well, let's just go over this so that you know just where you stand on things. And I don't want you to, you can ask me a question, but you don't need to answer on any of this. I just want to make sure you understand fully, since this is what we call an initial appearance. This is the first time you've been here. So initial appearances, what we do is make sure that the defendants understand fully what they're charged with and a little bit about the nature of the case and what the potential punishment range is. In this second degree felony of assault on a peace officer, you are looking at, if convicted, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Serious. Have you ever been charged with anything before? Never. Okay. Well,
I was inside of my both police, but I choice.
Well,
one is true.
let's, well, Mr. West is a good attorney, and just follow his advice. I'm going to reset this for 4 weeks since he's not here. This next event will be what we call an announcement. You will hopefully have discussed all this with him and then decided where y'all are going to be headed on the disposition of this. Okay. Get a resetting from that lady. Thank you.
Mr. Stevens.
Markham Champagne, Mr. Champagne,
I'm gonna give you the
23 CR 705.
So I'm gonna deal with the highlighted access one. And they'll give you a copy, okay?
Come on in. Are you Markham Joseph Champagne?
Yes, sir.
You're charged with the state jail felony of forgery. Okay. You know what it's about?
No, sure, I do not.
It's looks like a check. It's written in the amount of $4,900 purporting to be the act of another person on their check, and apparently, according to the authorities,
Was that to do good credit?
it is.
Okay, I'm already currently on probation for that.
Who is?
I am at Jasper County. I have paid all the money back. It's all said and done. As far as there were checks wrote here,
Yeah, well, every time you write a check
Yes.
in every location, that's a crime in a different jurisdiction. You have to clean up all the messes.
Yes, sir.
And this is,
Cleaned it
this
up.
is,
It-
well,
Got receipts.
no,
showing
this
that
is
it's
something that
paid.
was done here in Beaumont.
Your Honor, I believe there's 2 written here and 1 in Jasper. I can contact the Jasper office to see what the restitution amount is in that case and see if it covers the amounts written here as well.
Make restitution.
For what, for which, check, for all the checks?
Yes, sir.
Okay. Well, no. What's odd about this is, have you been moving around or anything?
I just recently moved, Your Honor, from Winnie to Bronson, Texas.
To where?
Bronson, Texas.
Okay. See, this indictment is very old.
Yes, sir.
And which is, anything unusual catches my attention.
Right.
Because things work in a certain way in coordination. Generally, within weeks or a few months of indictment, the defendant comes in for their initial appearances, not 27 months later.
Yes, sir. I understand.
So this was indicted in June of 23. And it states that you committed the state jail felony of forgery here in Jefferson County, Texas. And
I spoke with a detective about it.
Yeah.
And
he didn't, but
I asked the detective if something is done over this to please notify me. I will turn myself in.
Okay.
And that's exactly what I've done.
All right. Well, here, well, it's come to light.
Yes, sir. I
And
didn't
you just
even
need
know
to
I
deal.
had warrants.
Well, just deal with it in a responsible way. You know,
Yes, sir.
it ought to
What
work
I'm
out.
trying to do now. I turned myself in on the.
Good. This says it's a check in the amount of $4,900 that went to Do Good Federal Credit Union at 1795 North Major Drive.
Yes, sir.
And it was,
Like I said.
and it was returned back, not authorized counterfeit check. So that then gets it. Gets investigated by the Beaumont Police Department, and they file a report dated January of 23.
Yes.
So that's going on 3 years almost.
I wish I'd have known it had.
Well, it's sometimes things don't get out, and
Yes.
and if you, this shows your address, 521 McDermott, Winnie. When was the last time you had that address?
6 months ago.
Okay. Well, I don't know why it didn't work its way to find you earlier, but you got to just deal with it here. And
Yes, sir.
it's something that can be worked out. It's not a crime of violence.
Yes, sir.
And is there a loss of $4,900 to this bank, or did they stop the check somehow?
Your Honor, I believe there's 2 cases. They're both checks. One is for $4,000, one's for $4,900 here. And to my knowledge, there is a loss of that amount. He is correct that there was another check case in Jasper. I don't know if the Jasper case collected all the restitution. That's something I would have to call and find out. It's all to Do Good Credit Union, just different branches.
There is a second indictment, 23 CR 706.
Yes, sir.
That was also handed by the grand jury on June 21st, 2023. And it states that on October 27th, which would have been the day after the other indictment date of an event, on October 27th, 2022, you passed forged financial instrument to the victim, which was in this case. Do that again, the same bank. Yeah. You wrote another check for $4,000. So you got a $4,900 check on one day and then a $4,000 check on the next day. You understand? Okay, so you got two indictments and they're both state jail felonies, which carry with it up to 2 years in the state jail. They're convicted on each case. So what are you doing about a lawyer?
Not have one.
Okay, you're unable to hire one?
Yes, sir.
You need to fill out one of the indigent forms. We're gonna give you that, fill it out, then come back and swear that it's all true and correct. Don't make any false statements.
Yes, sir.
And if I deem that all is well, then you will have an attorney appointed to help you, okay?
Just sit over there and fill it out and come back to me when you're done. Judge, you did not call this person. It was on the first page.
Inland Fault.
Sir.
Finland.
Sir, behind the wall.
25 CR 122. That's you, Mr. Paul? Okay, this is initial appearance as well. You're charged here with second degree felony of aggravated assault with a deadly weapon, but it's not good. You've been here before, right? Have you been here on this case at all before, or is this the first time? You got two convictions, robberies in 2002 out of the 252nd District Court next door. After that was final. This says you committed the felony of illegal possession of a controlled substance and were convicted in the court next door in 2019. Thereafter that conviction, it is alleged here in this new indictment that you committed the second degree felony of aggravated assault. This would be generally a second degree felony punishment of no less than 2, no more than 20 years confinement in prison and a fine up to $10,000.
Yeah.
But because you had those three priors and 2 of them on one day in 2002, the third one is years later, but those are never in the past. They can always be used against you. You are looking at habitual felon status. If convicted of all of this, you're looking at no less than 25 years in prison, nor more than life. It's about as serious as it gets. Are you getting a lawyer? Are you able to get a lawyer?
At the moment, I'm probably gonna have a job.
I'm sorry.
I have a job.
Okay, where do
At the
you,
moment, he can, Judge.
where do you work? How much are you making an hour? 34? All right. Well, that's a fortune for a lot of people. How much time do you need to go talk to some people to hire? You got 4 weeks, okay? And then come back, see where we are on this. You're in a minefield. You gotta be careful walking through it. You don't want something to blow up. Because these are big explosions, 25 to life. See if you can fix that. Get with a lawyer as soon as possible. If you're unable to, come back. We'll take care of things. Thank you. Emmanuel Flores. Emmanuel Flores, please. 25 CR 1116, Emmanuel Flores. There is no answer in the courtroom. I asked the bailiff to call into the hall for Emmanuel Flores, please. What is this bond?
It's a $5,000 cash bond.
There's no response, Your Honor.
No response to the name called here in the courtroom. No response to the name Emmanuel Soares called into the hall by the bailiff. Defendant has failed to appear. A warrant was issued for his arrest. Did you say it's 5,000?
5,000, it's 5,000 cash is what he posted.
His cash bond is revoked. It is doubled to $10,000 for failure to appear. Plus, he must have a GPS device. So we know where he is when he's not in court when he's supposed to be. Yanni Mendieta. Yanni Mendieta, 25 CR 529, please. Yanni Danielle Mendieta, no answer in the courtroom. I asked the bailiff to call into the hall for Yanni Mendieta.
There's just gonna be the same scenario of $5,000.
No response to that name called into the hall. No response to the name called here in the courtroom. Yanni Daniel Mendieta. He has failed to appear. A warrant shall be issued for his arrest. He had a $5,000 cash bond too. They must have been working together on this one, huh? It's the same offense.
Different offense, but.
Your Honor, it looks like the last time he was scheduled for court, he was also a no-show.
What did we do? It was a no-show last night.
I'm showing the last time he was scheduled on an initial docket, he was also no-showed. Bond was revoked.
I'll have to look at the file, Judge. I don't
All
know
right.
what happened with it. Sometimes they.
It's $5,000 cash, right?
Right.
So it's revoked and it's doubled to $10,000. Plus, he must have a GPS device as a condition of bond.
And Judge, this is someone on the first page. You didn't call their name. It was one of John West's people.
Jovan Soraya. I guess John's still in another court, huh?
Right. Have a county judge.
Is he gonna be back this afternoon? Do we know?
But he did tell me he needed. He's on.
How do you pronounce your last name?
Soraya.
Soraya? Sarah?
Yes, sir.
All right. Jovan, Sarah, are you charged here in 25 CR 1196 with evading arrest or detention with a motor vehicle?
Yes, sir.
If convicted, it's a third-degree felony, which carries with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. Do you understand?
Yes,
Serious.
sir.
All right. And Mr. West is your attorney. Have you had a chance to talk to him yet? No? Does that no? Yes, speak out. So she.
No, sir.
Okay, yeah. You need to. You need to be in contact with him as soon as possible. Because again, you're looking at up to 10 years in prison. That's serious. Yeah. I'm going to reset this for 2 weeks. God bless you.
God bless you.
And did you ever did you know Mr. West was going to be your attorney?
No, sir.
Okay. Okay. He's one of the public defenders. So please note on these two that they are waiting to hear from him. He needs to contact them. And I'm giving them 2 weeks. Okay. Thank you. Get a resetting from that later, sir. Thank you.
Time return, the highlighted X.
Dale Demond Langston.
Oh, Judge, that's the
I need some.
defendant that is in TDC.
Is he?
He is.
This guy's moving around. No, he's leaving.
Yeah. Yes, sir. I checked the TDC roster number fine.
I'm sorry, sir. Did you have? We're good. You're just moving through? How's it going? Oh, okay. I mean, you're always in place. It looks like you're having a hike or a good time. He's gonna come back with a beer, watch. Jeremy Broussard. On, Mr. Broussard, what are we gonna do, Mr. Banks?
So this is our first setting. I just spoke with the prosecutor and.
How's that going?
It's going well.
Oh, that's
So I just received an offer and I need to discuss it with the client. And also the discovery that I got into yesterday. So I'll do that between now and the next setting. You have something to
How much time? do you-
30 days.
How about 4 weeks?
That's fine. Depends on if it's in February.
Give me 30 days and wisely you're putting that into a weekend. Good work. Good trip. But 4 weeks, good. All right, get it reset. Thank you. Yes, sir.
Thank you, Jimmy. I need to
Everything, Jansen, you need anything else? Everything?
Yes, thank you.
Okay.
Where are you gonna do well?
Cody Hatch. Cody Hatch.
Judge.
Mr. Crenshaw walked through and we're gonna pass on that one since he did a walkthrough. Come on out.
Can we recall that in 5 minutes, Judge? So the prosecutor.
Yeah, you got it. Troy Steins. Oh, that's yours too.
Yes,
Was that another 5 minute?
please.
Okay. DeMarcus Jones. DeMarcus Jones. DeMarcus Jones is charged in 25 CR 373. Is that you?
Yes, sir.
And Dustin Galmore is your turn?
Yes.
Have you talked to him today?
I haven't heard from him today either.
Sorry. Wait a little while. If he doesn't show up, I'll just have to reset it and I don't want you to waste your time. So that's this. Stand by. Thank you.
Up here.
Jonathan Luna. Jonathan Luna. Is that you, sir? You're, come on, is Mr. Galmore your attorney still? Is that right? He's not here. I don't know where he is. You got 2 cases. No, one case here on evading arrest. We'll wait a little while. If he didn't show up, I'm gonna have to reset it. Okay, sorry, waste your time.
Okay, we're ready.
Okay, we have a sequence that's talking to me, okay?
Sorry, I've got these other 6 pages and I'll get right to you. I'll get these up, when I get these other 6 pages done, I'll go right to you.
I'll just sit over here and read them.
Wait, where'd you get that copy?
It'd be rough.
Hey, didn't we raise the price on that copy, didn't we? For Corey?
Yes, specifically.
Is it Cody Hatch? You want, don't, okay, come on up. Cody, here's Corey. Corey, here's Cody. How's that going on the city council thing?
So. It's a true taste.
Let me tell you,
Test.
you're on
of
YouTube, you
patience.
know.
What's that?
YouTube. Did you change makeup?
I did. I'm going with a little.
A darker fall.
How's it here? It's an old trick.
Finally. Okay, what are we going to do here on, and Mr. Hatch, 23 CR 1093, you're charged, as you know, with this operating a motor vehicle in a public place while intoxicated, and because you have these 2 other DWIs, every time it's a DWI, it's a felony. So you got to be careful. And this is a 3rd-degree felony, so you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed in accordance with this case. So navigate through it. He's your guide through this minefield, and but it's fixable. What are you doing right now to immediately to make sure that you don't get in trouble again? Yeah, I guess you have an interlock device.
I was had it for all 2.5 years. I never blew positive.
Good Lord. It is. This was indicted 2 years ago.
Yes, Judge.
What the heck?
The previous prosecutor on the case, we were working towards a misdemeanor. Now that we have a new assigned prosecutor, she's indicating that there's no chance of that, so we'll just try.
Okay, all right. Then, yeah, this is stale. We gotta work this thing out, expediently, and that's way too long. Let me read this one. But y'all didn't have a deal on the other, previous, you didn't have a
There
deal?
was-
The notes.
There's not anything in the file about reducing this to a misdemeanor, Your Honor.
Okay.
There's an offer on the felony, but
He wasn't operating as our defense, and so our experience in interviews really don't like cases where people.
Did
are trying
did
to-
they do a blood test or something on it?
yes, they did.
No, I never get those until the trial. What is it? What was
Believe
it?
it
Just
was
for
a
my
227.
curiosity.
227.
Oh,
BAC isn't the issue, Judge. As you can read in the PC,
well, yeah, it
lack of
says,
facts of driving. So.
okay, so he's asleep in a vehicle that's running and nobody else is there and the police, so it was just placed to sleep or something.
It was a safe area. And case law is very clear. Engine running, it's not.
Lucky you didn't get carbon monoxide poisoned. Well, that could have been dangerous. All right, let's set up a trial. Let's go. We can do that.
Great.
Troy,
There you go.
Troy Stein.
Oh, here's some.
Yes.
I need to do Congress.
Troy.
That's also a new prosecutor, Judge. I'm gonna get.
Prosecutor, but.
New prosecutor in the case.
He'd have been the last one.
Stipulated.
He'd have been the last
Very
one.
old prosecutor.
I'd have called that.
But new to this case, and I'm gonna get him some information, and if we could come.
We didn't
back
have
with
information before.
Another announcement. Well, we've had and positive movements, so.
Hey, let me ask you,
Sure.
Corey J.H., you have two middle initials? I didn't know that.
I'll try to let you know it's.
I'll be doing it.
Yes. It's hell of a monogrammer. Yeah, they don't.
Wait a second. What'd you say?
Couple extra dollars.
Yeah, that's gonna cost
Well,
you.
well, no, they usually only will do 3 initials, so it has to be a special request. Just, it's a lot of paperwork.
Yeah, after this, he'll probably have 5 initials.
Yeah.
What are you gonna do today?
If we could just come back on another announcement, I think we'll get this one resolved.
Is 4 weeks good, you think?
Sure.
And
Remember,
that was an old too.
Christmas weekend.
Man, I don't know what you missed. You have filibustered long enough on all of these. This one's 2 years old too. Mr. Steins needs to move on with his life one way or the other, huh?
Well, we're certainly prepared. It's just a matter of which charge.
Good luck on this. Yeah.
Seeing just right now.
All right. Get a resetting 4 weeks. Hopefully there'll be an end to this soon.
Yes, sir. Understood.
Highlighted X point.
Yes, ma'am.
Thank you, Judge.
Is that
Good to
it?
see you.
Oh, cool.
Enjoy the visit.
Mr. Crenshaw.
There you go, man.
Yesenia
Thank you.
Alvarez. Yesenia Alvarez. Get nothing done today. Just spinning our wheels today. Get nothing done.
No.
Mine. You're not gonna like my response.
25 CR 348. Yesenia Alvarez. That's you? Says Langston Adams. Was Langston Adams representing you for a while?
No,
No?
pointed out at the jail, Judge.
Yes, I believe
Sometimes
that's
that
what
happens
happened.
when they're in there.
Because that's what's showing on the
Forever, they
jacket.
pointed it at me.
Okay, you know, you're charged with state jail felony, operating a motor vehicle with a child under 15 years of age, which carries with it up to 2 years in the state jail. You got it? You have to speak out. Yeah, you understand? Okay. It's the least serious type of felony, but nonetheless, who wants a crime, right? So work it responsibly with him. What are we gonna do today?
Judge, if we could get 30 days, so I can work through this with the prosecutor.
4 weeks good?
4 weeks.
Okay, get a resend. Thank you. Francisco Torres. Francisco Torres. 23 CR 5 3.
Found all the highlighted exploits, you think?
Judge,
This
Mr. Boyd and I had been.
DWI.
Yes, sir.
Okay, and you know, it's a 3rd-degree felony. You're looking at no less than 2, no more than 10 years confined in prison, up to $10,000 fine if convicted. So it's serious. You want to deal with it responsibly. What do you want?
Judge,
Well, these are 2 years old.
and then we've gotten got shuffled around to some prosecutors. So, but I think Mr. Boyd and I were close to working out a deal on this. I haven't seen him yet this morning, but it was easy in the back. It wasn't. Maybe.
Is Dan here?
He was earlier. Yeah, he's getting ready for some hearings this afternoon.
We don't have an reach to get that.
It's 2.5 years.
I know.
Well, can you get an agreement in 5 or 10 minutes? I mean, it's a DWI. These are never mysterious. There he is. You know Ryan Gertz?
Yes, sir.
Attorney.
I texted you this morning about this.
Okay. You want to go out and get a beer first?
Yeah.
Come back and see what happens? Okay. He's 2 years old, DWI, and on Francisco Torres. I think you inherited it.
Yes, sir.
And I think Ryan doesn't want to wait forever either. So can y'all work on this one
Yes, sir.
while everybody's here? Okay, good. Let me know.
Give us a few minutes, Judge.
Yeah.
We needed a plea form in Lewis, right?
Well, oh, I'm sorry. I was just giving, we're ready.
I mean, if you need some time, take some time. We'll
He
recall it.
understands everything that's going on.
All right, so we're here today. This is case number 25 CR 42801.
Commissioners.
You may. Present before the court is Mr. Kavanaugh, represented by Mr. Newberger. We have Mr. View from the prosecutor's office and Officer Torek from probation. We're here today for sentencing. So everybody had the opportunity to review the PSI.
Yes, Your Honor. Yes, Your Honor.
Does 4 days of jail time credit sound right to everybody?
Yes. Yes.
Mr. View, on behalf of the state.
Your Honor, as we discussed in chambers, the state's has some concerns regarding how to effectively monitor Mr. Kavanaugh, but my understanding is the recommendation from probation is for community control with a fairly significant local jail term. Under those circumstances, we're satisfied with the recommendation of the probation department.
Officer Torek, what's your take on all this?
Nothing more than discussing.
Mr. Newberger?
Nothing beyond what was stated in chambers. And by the way, I may not have signed the affidavit myself. Are you okay with that?
That's fine. All right. What do you want to tell me, Mr. Kavanaugh?
Well, Your Honor, I made a mistake, a big mistake, and I apologize for that, but there's no excuse. I'd really like for you to look into your heart and give me probation. Been out because I've been here 62 years in Warren County. And I've got a car, I've got a job, I've got a stable place to live, and I got a dog at home too that nobody to take care of. And I just hope you can look at it in your heart to give me a chance to stay out and report in probation. I'm done probation before, about 22 years ago. Haven't had anything for 22 years. And that was by, a mistake. We both had to plead out for it because it was in her car, in her ashtray. So, and no excuse. But I wish you'd look in your heart and let me stay out of jail. I dearly believe that I can come to you guys on probation.
Yeah, I'm not going to do that, Mr. Kavanaugh, and here's why. The popular thing right now is people who are on medication-assisted treatment. Methadone, Suboxone, Vivitrol is kind of a thing of the past, but we have all of these people on these different kinds of medications, and it's part of their treatment. And therefore, because it's part of our treatment, it used to be we didn't have methadone in the jails, we didn't have methadones in our treatment facility, and it was, you should probably get off drugs if you want to be in a treatment facility. That's the way we used to look at it. Now, whether it works or whether it doesn't work, I don't know that there's enough data out there to support that either way, but people have access to medications while they are in treatment. And people who sell the medications that they are on their treatment for need to be punished for that. That doesn't mean that we don't have a treatment piece to this. We do, but there is also a punishment part of it. So I am going to put you into my community control program. I'm going to do that for a period of 3 years. We're going to give you some rules to live by, and you're going to follow those rules. So you're going to be subject to random drug testing. Of course, you're going to be allowed to take your methadone. Although if I were you, Mr. Kavanaugh, I would consider finding something else that works for you other than methadone. I'm not a doctor, and I don't pretend to be a doctor. I just know from my experience that methadone is terrible, and it is not a good way to solve your problems. You need to play the long game in this and figure out a way to get through the day without taking a medication that you have to take every single day. And, but if you want to take methadone and you and your treatment provider and your doctor say it's okay, we're not going to stop you, at least at this point, but you are going to serve 90 days in jail. And I will allow you to break that up into 2 blocks, and you can schedule it through probation. So you and Officer Torek are going to pick some times where you're going to report to the jail. But that is just good old-fashioned punishment, Mr. Kavanaugh, because that's my way of saying to you and everybody else who might do this, if you do it, there is a consequence, and that consequence is pretty significant. I'm going to give you credit for the 4 days that you have already done. Also makes sense to have you complete a corrective thinking class, and we need to continue you in treatment. I find that you're indigent for the purposes of fines and costs, so there won't be a financial sanction. If you violate the terms of your supervision or you leave without the state without permission, I can sentence you to up to the maximum penalty in this case, which is 36 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the costs, they'll all be provided to you without charge. Good luck to you, Mr. Kavanaugh.
Could I ask the court?
Sure.
I'm not sure that Mr. Kavanaugh understands a very important thing you just said, that he can schedule the 2 blocks of jail time.
Yeah, you're not going to jail today, Mr. Kavanaugh.
You can schedule it through probation, and then he would have work release and or litter pickup.
Oh, yeah, I did not bring that. Yeah, if you can get work release worked out, I'm fine with work release.
Okay.
Or if you want to do the litter pickup program, that means that you get an extra day of every day that you do on litter. So if I send you to 10 days in jail and you go out 4 days in litter, you're out after 6 days.
So I can come up here and do community service.
That is why you're in the jail.
Oh, that's why I'm in the jail.
Yep, they have a crew and they go out.
Okay.
Do you understand?
Yeah, I understand that.
So you're going to go into probation, you're not going to jail.
Let's we'll go ahead and process the litter entry just in case. All right, good luck to you, Mr. Kavanaugh.
Appreciate it. Thank you.
All right, and you need a few minutes on the Lewis case, right?
Do I need to go to
Probably,
probation?
yes, 5 to 10 minutes.
Okay, that's fine.
Right, you do.
All right, Sinclair is set for another
Meet him right now, aren't you?
finding things today. We were looking for, I know you'd filed an affidavit of cost, but I couldn't find it. We did finally find it. Anyway, I got this order. It's not date stamped. But you filed it shortly after the hearing, I think maybe on the 30th. We'll address that in a minute.
It's on September 30th.
All right. It's not date stamped, but we think we discerned that. All right, that's an order following the civil contempt hearing in 25040CZ. That's what we'll refer to as the birthing center. In the adjacent building that was subject to a stop work order, that is filed 25533CZ. I entered a permanent injunction on that day. I wrote the 23rd, but it was the 24th. In that case, the defendants filed some last minute briefs in that matter shortly before the hearing. I think they were bench filed on that day and they weren't addressed. And I said I would address those hearings today. Mr. Thornton has filed a responsive brief. Then yesterday, I saw the defendant's associate here at the courthouse and we said hello. And I surmised that she was here at the 11th hour filing some filings again. And they never told me, so I called the clerk's office this morning to say, did they file something yesterday? And after some searching, I was advised that they did. So they filed more things effective yesterday in the 040 case and the 25533 case. So let's set aside the adjacent structure 25533 for a moment. We'll come back to that. I'm going to sign the order that I should have signed a month ago or weeks ago. I'm going to sign it effective 15th of October, granting the relief I ordered on the 24th. Would you please make 2 copies of this, one for Mr. Thorne and one for the defendants? All right. We've got a couple orders of business, and it's hard to try to keep everything straight. After I made my rulings on the 24th, the permanent injunction default that had entered remained in place. Mr. Thornton requested a fine of $3,500 per defendant and cost for the township. He was true to his word and he filed an affidavit of costs, setting forth the cost that his office and the township had put into this matter. We'll address that in a minute. On October 6th, the Yoders filed a filing package for the October 15th hearing. And the problem is it mixes the 2 cases together. It's got 25040 and 25533 penciled in. So the 40 case has just to do with the birthing center. One of the documents here actually does have some relevance. Motion for reduction or admission of fines. This court has scheduled a hearing to determine the civil contempt fines. That statute authorizes the court to mitigate or discharge any fine where a party has purged the contempt and complied with the order. Defendants have ceased construction and abandoning the birthing center units and now seek lawful residential permits. Continuing to impose large fines serves no remedial purpose, will be punitive and excessive. defendants ask this court to exercise its discretion to reduce or remit all civil fines and close the contempt matter. That's the most relevant pleading I've actually seen in all the pleadings. So Mr. Thornton requested a substantial fine and costs. As we know, you've each posted a $1,000 cash bond with the circuit court for failing to appear for one of the hearings. Judge Stutzman ordered a bench warrant with the bonds, and you posted the bonds, and the matter was continued, and I've been holding those bonds since. So the first thing we're going to do is address the issue of the fines and the costs. I'll hear from Mr. Thornton first, and then I'll give you a chance to respond. That pleading actually was pretty good. The law is different in zoning matters. In most cases, most criminal cases, if you're charged with a crime, you don't generally have to pay the cost of the prosecution. There are some exceptions that specifically allow for the cost of prosecution. And if you were charged, for example, with driving suspended under Sturgis City Ordinance or 3 River City Ordinance, and they had a trial, and the prosecutor spent $2,000 preparing for the trial, you don't have to pay for that. They don't get to ask for costs of somebody having a trial in the matter. People have a right to have a trial in the matter. So they shouldn't have to pay a premium for it. As I indicated, there's a couple of statutes, drinking, driving, and some others, which allow the court to order the cost of prosecution, but it's very rare. However, in zoning matters, the cities and villages and townships will often ask for their costs. To do zoning enforcement costs all the people in the township. So Mr. Thornton has asked for a fine, and he's asked for costs. So Mr. Thornton, at the close of the last hearing, you asked for a substantial fine as to each defendant. Would you like to speak to that?
Sure, Your Honor. The statute for contempt, the section 600.1715 is the one that addresses the fines and allows for up to $7,500 per defendant. So in my discussions with township officials, we came up with the request for $3,500 for each defendant for a total of $7,500. As far as the fines, the
3,500 times 2 equals 7,000.
7,000, sorry. But that is correct. 3,500 each times 2 for the 7,000 total. The township's restitution request is based on 600.1721, payment of damages essentially caused by the contempt that the defendants have found to have committed against the court orders. And that's, as I read it, mandatory. The court shall order the defendant to pay such person a sufficient sum to indemnify him. When I submitted the affidavit of costs, it only sets forth costs that I believe relate directly to the civil contempts and the additional costs that the township incurred because of the civil contempts and the failures to appear. So that even though it's a substantial amount that in the affidavit of costs of $3,885.50, that certainly does not even come close to what the township has spent in case 040 to get it to where it's at today. So I leave it up to the court. It is the court's discretion on the fine. But I do request the restitution to the township as to the affidavit of costs and in addition to the motion, let's see, the taxable costs that were incurred, all set forth in the affidavit of costs. So so as I calculate those, there's $3,994.46, all accounted for in the affidavit of costs. There is $265.48 in the cost ordered in the default judgment in case 040. And I'm requesting an additional $190 in cost for responding to defendant's filing package in case number 040. And I believe that's the recent one Your Honor was mentioning.
The October 6th one are the ones we got yesterday.
No, that doesn't, the October 6th ones.
All right, so is that 190 in your bill of costs?
It's not, Your Honor, because it came in.
You
after-
did put in an hour estimated for today.
For today's hearing,
All
but
right.
that 190 is just responding to that motion. On October, that what they call a filing package
Yes.
on October 6th. And there was one filed in each case, and that's just for the 040 case. So that totals for 040 case, $4,449.94.
All right. Thank you. I knew you had prepared it. I had a heck of a time finding it, but we did find it. It was date stamped the 30th. I don't know how they do things at circuit court. When a motion is filed in my court, I'm given a copy of it. They just, maybe it's because I'm a district judge by assignment. It just gets stuck in an electronic file. The original is destroyed. Although I would manage to save the originals from yesterday. And then it just goes in the file and they don't say, hey, this got filed, or I guess, I don't know if he looks in every file every day to see what got filed, but anyway, it's a system that's different than the one I'm familiar with, but I knew these things were out there. All right, Mr. and Mrs. Yoder, I tend to agree with you that you are in compliance with what was originally ordered. You don't necessarily like it, but you've accepted the inevitable. You've ceased to operate the birthing center, at least at that location, and you stopped construction on the adjacent building on the lot next door. We're going to talk about that case in a minute. And to assess a large fine of $7,000 on you and your family seems to me to be overly punitive. And as Mr. Thornton mentioned last time, the township doesn't get the fine. It goes to the court and to the state of Michigan, and the court has discretion in the fines. As he indicated, the statute doesn't give so much discretion regarding these taxable costs. The statute says the judge shall assess those costs. That's 600.1721. So I don't have a lot of discretion. Mr. Thornton has a billable rate, which is lower than many attorneys, certainly in a larger city. This was a Detroit law firm, or even Kalamazoo or Grand Rapids. That hourly rate would be substantially higher. And truth be told, he probably has more hours into it than is on the billing. Also, this is only his cost as to the contempt portion. The matter was set for hearing in front of Judge Stutzman. You didn't show up. There was a show cause. You didn't show up. A bench warrant issued. And then sometime after the bench warrant issued, Judge Stutzman asked to recuse himself and asked me if I would take it. So this train was quite a ways down the track before I got on it. But I'm going to grant a cost as assessed by Mr. Thornton in his bill of costs. But before I do that, I guess I ought to give you an opportunity to be heard on that. I'm not going to assess any fine. But he's filed an affidavit of costs. And do you wish to respond to that?
Negative.
All right.
Yeah,
Yes?
so, I object because we are already complying to good cause. So why should we be punished with a fine?
Well, I don't necessarily disagree with that. So I'm not giving you a fine. They asked for $3,500 apiece and you are in compliance. So I'm not ordering any fine. What I am ordering is that you pay the cost of what the township had to pay for your failure to appear and all the contempt rigmarole that we went through. As I said, that one was well pled. So I'm granting plaintiff's request. It's in the bill of costs for attorney fees of $3,885.50 plus $190 for responding to the October 6th motion. Plus taxable costs of $108.86 plus the earlier costs of $265.48. If we add all that up, it adds up to $4,449.94 offset by the $2,000 bond. Which leaves $2,449.94 due within 30 days. That is just cost. There's no fine. All
I
right.
did prepare an order, Your Honor, but I'm not sure. It doesn't really take into consideration the 2,000 from the bonds. But I don't know if Your Honor wants to review it and mark it up. Or...
Yes, let's try it.
Two paragraphs on restitution, one for each defendant, and two paragraphs on fines, one for each defendant. Obviously, under the court's ruling, the fines would be 0. And then I set it up so the restitution would be divided between the two defendants, since there are two defendants.
Well, I'm going to do it joint and severally. $2,449.94. The total amount is $2,449.94. It's not twice that, and you're jointly and severally liable for it. If Alfred pays the whole thing, that satisfies Joanne's obligation. If Joanne pays the whole thing, it satisfies Alfred's obligation. If you each pay half, it satisfies your obligation. So the total amount is attorney fees, the previous court costs, and the related costs, jointly and separately. They don't get to collect it twice.
Your Honor, is the order reflecting that the $2,000 bond is also going to be forwarded to the
Yes,
township?
thank you. $2,000 cash bond. 1,000 per defendant. Well, it's already been applied. Was applied. To total of 4,449, 94, 44994. So the total, I'm going to change that. 4,000. Maybe clean this up. 4,449 less $2,000 cash bond. So each defendant owes 2,449 jointly and separately. All right.
So does the order reflect, and the clerk's office will know to forward that $2,000 bond to the township?
Shall be forwarded to the township. Thank you. That'll make it more clear for them. All right, so that's the issue regarding costs and fines in the birthing center case. Defendants filed some last minute motions just before the hearing and filed more motions yesterday. Mr. Thornton filed a response to the filing package filed October 6th. He filed that the very next day on October 7th. One of the problems is the thing had both case numbers on it. So it was hard to discern it, but you're asking to modify or clarify the permanent injunction. I didn't really understand all of it. Equity and change circumstances, statutory authority, due process of public authority concerns religious and cultural context. I had already determined that Judge Stutzman's default order would stand because the defendants had failed to move to set the default aside in a timely manner. Then after we have that hearing, they filed this on October 6th. Mr. Thornton objects to that on multiple grounds. So Mr. and Mrs. Yoder, we've got your October 6th motion and we've got your new motion filed yesterday. Motion and brief to recognize compliance, set aside default judgment, and for equitable relief. I'd said this several times, yes?
That one that was filed yesterday
Yes.
was filed yesterday because we got Lance's love letter Saturday and nothing was open Monday. So we had to wait till yesterday to file it. That's why it was filed last minute.
All right, well, I'm not aware of any letter, love or otherwise, from Mr. Thornton, but trying to be diplomatic here. I said from the outset that I first got in this case that you needed a lawyer. At one point, apparently you had one, Mr. Marvin, and I don't know, that didn't go very far. I'm not sure what happened. You got advice from people that aren't lawyers. And in essence, they're practicing law without a license. And most of the advice they gave you was bad. You ended up almost going to jail because you took advice of people that don't know what they're talking about. You got bench warrants issued for me from Judge Stutzman. You may well have had some defenses to these matters. My sense of you folks is that you're honest, hardworking, Christian people that wanted to provide a service that people want. There is demand for your birthing center, and you have a great community support for that effort. But you can't do it where it is. This wasn't my idea. This is how it came up. In fact, I'm still dumbfounded that there's not some sort of state licensing or something for such a facility, but that never came up. That you just wanted to do your work and have everybody leave you alone. And frankly, most people probably feel that way. But you can't do what you were doing where you were doing it. Judge Stutzman had made a finding of default and he entered that order. So I was operating from that order, but they heard maybe some testimony about problem births or other things I don't know. My son would have died if he was at your birthing center. He was an emergency C-section and they called Dr. Don in the middle of the night. He came to Three Rivers and did a C-section on my wife because he was a frank breech. Those are decisions I don't have to deal with because this judgment already entered. So people want you to provide this service and maybe it can be somewhere that's close to other hospitals or facilities if there is an emergency. But all this stuff that gets filed at the last minute, the day before the hearing, it's not captioned properly, it's not signed properly, it cites stuff that isn't legal authority. You've been taken advantage of by people that are well-meaning, but they don't understand what they're doing. It's to your detriment. So you filed these motions. All right, first, let's talk about the October 6th motion. Yes, Mrs. Yoder?
So when we was here to meet you first, if you gave us the rights, I wrote a note here for me. You had said that we can respond in any way, handwritten or anything, why are we being judged and how we respond?
Yes, you can. It isn't very effective. You're sincere about it, but you don't. The law is complicated, and you're all here witnessing that. It's complicated, it's cumbersome, it's expensive. And you're doing the best you can, but your responses don't comply with the court rules and don't constitute a defense to the township's action. I'll repeat myself for about the 10th time. Judge Stutzman ordered a default judgment. You didn't show up for the hearing. They had a show cause hearing. You didn't show up for that. Bench warrants issued for your arrest. So that order was already issued. Now you're asking me to set aside the default on October 6th, and you're asking me to set aside the default again on October 14th. That ship has sailed. So maybe I don't understand your pleadings well. In fact, I'm not sure you understand them well. But let's talk about the October 6th pleading. What are you asking me to do?
Let me finish my building. As a
Yeah, well,
residential,
we're gonna get to that one in a minute. That one, that's legit. That looks like a nice, well-built building that could have a purpose. Right now, we're just dealing with the birthing center case. We haven't gotten to the building case, but I went out and looked at it, and it looks like a nice building, and it could be something that you could utilize. You got tens of thousands of dollars into it in material alone. So we'll see if we can come to an answer to that question. But right now, we're in the other case. When I got this, I thought, well, I'm gonna have to follow this to the end. And we got to figure out what to do with that other building. And we'll try to address that here in a minute. All right, Mr. Thornton, any further response to the October 6th filings?
Yeah, Your Honor, in reviewing all this, and it gets confusing for me too to deal with all the filings, but to my knowledge, in the 040 case, there was not one motion set for today for hearing. There was no notice of hearing ever served upon me and my office. To my knowledge, there was never anything scheduled.
Well, I had scheduled the last minute motions in the
533.
In the 533 for today. Yes, okay, so
I agree with that.
this one says 040, but it wasn't noticed for anything.
Correct.
All right.
And I guess what I'll state is the Oders are arguing that they've complied. I'm not sure that's clear at this point in the 040 case. And one of my responses, I did make the court aware that the babies are now being born on Mountain Road, and then mom and baby are transported to 30100 Marsh Road, the Oders property. It's the subject of the 040 case for.
I object to that one.
Well, that's not testimony, so I guess you can't object.
And this is based upon information and belief, information I'm getting out of the clerk's office, from birth certificates being filed there, and secondhand information that the township's getting from witnesses. So
where are they being born now?
Mountain Road, in a home on Mountain Road.
Is that in Colon Township?
It is. And then the information we're getting is they're transported over to the birthing center and for aftercare and a stay there until they're ready to leave.
Well, I don't know the answer to that one. I don't know. Maybe we aren't done with this case. I had hoped that we were.
I'm not asking the court to address that. I realize that's going to have to be addressed in the future, but the orders are basically arguing that we've complied in 040 case, and therefore the whole default judgment, permanent injunction should go away. And there is just no legal basis for that argument that we complied. Therefore, the judgment and permanent injunction should go away. Certainly, as they have done, and the court has recognized that was an argument for reduction or waiving of the fines, but not to set aside, as they've requested, the default judgment.
All right. I have heard their plea in the motion for reduction or remission of fines, which essentially I granted in full. The motion to set aside the default from the October 6th motion is denied.
Your Honor,
Yes.
I object to that. September 24th, we were asked to give no care to pregnant women at 30100 under lots of stress. We have faithfully followed the court order. It is heartbreaking that our elected township has become so distressful that a simple family gathering or visit from friends and relatives are treated as a violation. We have a pregnant daughter and pregnant daughter-in-law who cannot even come to our property without being stalked or accused of breaking the law. This is not justice. This is prejudice. We hope these watching and listening today will see that we are peaceful people trying to do what is right. Please help us restore the fairness and stop this unlawful behavior by township. We have shown good faith and asked for good faith in return. We've done everything the township has asked. We're compliant, we're peaceful, and yet we're still treated like offenders. This is not how community or justice should work.
Well, thank you for that. I haven't found that you've done anything else in violation. What you just told me is all news to me, just like what Mr. Thornton represented. You certainly should be able to have your family members come to your property, but that's not before me. I'm not finding that you violated anything else. At this point, I'm taking you at your word that you've stopped using this as a birthing center. So that October 6th motion is denied. Yesterday, and this is one I had to track down. I saw your associate here and she was cordial, and she had something in her hand and I thought, well, did she file more stuff? And it took me till about 10:30 this morning to actually get it. But this one is entitled, it's in 25040. It's entitled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Regarding the October 14th motion, the one that was filed yesterday, and you said you got some sort of letter from Mr. Thornton on Saturday. Don't know about that, but what are you asking me to do in yesterday's motion?
What can we do with that building?
Well, that's in 535. What can you do with the birthing center?
The Mama's house building. Because as it stands right now, the way I understand land, you can't do anything in that building.
Well,
we've got our belongings in there. I mean, it's crazy.
Well, you can, I don't know the answer to that. I don't know if there's more than one structure on that property. There's a house and maybe an adjacent house and then the birthing center. And I don't know the answer to that. Can you reside in it? Can you have a prayer meeting in there? Can you?
Well, prayer meeting wouldn't be allowed by Courtroom Township.
Your Honor, can I address that?
Yeah, I guess so.
The township's position has never been, and we've never told the Oders that they can't use 30100 as a residence. That's what it's built as. That's what it was designed for. And they can certainly continue to use it as a residence. Courtroom Township zoning ordinance allows 2 residences on 1 parcel. So the Oders' home at 30158 and the Mama's house current what was used as the birthing center 30100 are on the same parcel. So they can use both as residences. Township's never taken the position that they cannot use both homes as residences.
But the court order is very clear, and the default judgment, permanent injunction are clear that they can't use 30100 as a birthing center. So different from a residence. So I'm not sure where all this is coming from, that they can't do anything with 30100. It can be used as a residence.
Well, all right, fair enough. That answers that question. And again, it's too late to set aside the default. You're asking for equitable relief. Equity permits relief from judgment if it would be unjust, inequitable, or contrary to the public interest. Again, this order has already entered by default. And the defendant didn't move to set aside the default in a timely manner. So if there was no injunction and you were living there and your daughter and son-in-law lived there, or whoever lived there, that's completely within the recognized use in Colon Township. And the things that you can do in your own house, host Christmas, have a prayer meeting, have your grandkids over for the weekend, the kind of things anybody does in their own house. Those you can do. You can't operate it as a birthing center. So the motion for equitable relief and set aside the default are denied.
Your Honor,
Yes.
I just want to clarify the situation on as far as the 30100, because the way I understood in the last hearing, that it was made very, very plain that absolutely nothing to do with pregnant women. And
Well-
that's why I was very concerned about.
Well, let's take a look at Judge Stutzman's order. Default judgment and permanent injunction.
Actual order starts on page 3.
The above findings of fact are hereby incorporated and made a part of this judgment. Colon Township's request for adjunctive relief is granted, and the defendants shall cease operation of the birthing center on the Yoder property as soon as reasonably possible. I think we settled on September 1st or 3rd. Defendants and their agents, service, assigns, and successors in interest, or anyone in active concert with participation with the Yoders with regard to operation of a birthing center, are permanently enjoined from operating a birthing center on the Yoder property. Colon Township shall cause a certified copy of this judgment to be recorded with the officer of the Register of Deeds within 30 days of the date of this entry. No money damages awarded to Colon Township. Defendants are ordered to pay $265.48 in taxable costs. All right. You raise a legitimate question. There's no definition in here of what is a birthing center. The presumption is a birthing center is a place where people go to release their confinement and give birth to a child. If the children are born somewhere else and then come there, not sure what that is. That's a daycare center, but the birthing center is not defined. So your request for clarification probably has some merit to it. The order doesn't define it. I don't know that and did otherwise, but a birthing center, let's take it at its plain meaning. It's a place where people come to give birth. And you have a large following, you had more births of that birthing center than probably both Three Rivers hospitals combined, Three Rivers and Sturgis Hospital combined. More babies were born in St. Joseph County at your birthing center than anywhere else. Most of the babies here are going to South Bend or Elkhart or Kalamazoo, Coldwater maybe. So you can't have births there. Can you have children and mothers come there after they give birth? I don't know the answer to that. The township, if you do that, the township is going to ask for further relief. My hope was you could find a place to put this that would comply with zoning, either in Colon Township, in LaGrange County, in some other township, and then continue to provide your service. Frankly, that's what I hope. You've got people that want to use the service, you want to provide it, but you can't do it here. This just keeps poking at the sore point. So all I can tell you is what the order says. That you're not to operate a birthing center on that property. Mr. Yoder?
We are looking into buying other property in a township that's got a little more brain.
All right, well, I don't, like I said, there's a demand for your service.
Well, it's obviously, yeah.
So that would, that's what I hope happens. I hope you find a place to put this where it can be licensed and everybody's in agreement and you continue to provide a service that people want.
We have 2 townships that are begging for us to come their way.
All right, well, more power to you. All right, so that resolves the 2040 case. The injunction remains in place. You're not to operate as a birthing center. I've offered costs, I've ordered costs as they requested with Mr. Thornton's bill of costs. I've denied your motion of October 6th to set aside the default. I denied your motion of October 14th to set aside the default. So as far as I'm concerned, that case is done once you pay the balance of the costs. And that number is $2,449.94. Mr. Thornton, would you do an order denying the defendant's requests of October 6th and October 14th?
I will, Your Honor.
All right, let's go to the adjacent property. In the 25539 CZ. I could tell that this was going to be a problem that would need some further attention. As I said, I went out and observed it. So I did an order on August 29th, granting the preliminary injunction. Then on September 24th, I entered the default judgment granting the permanent injunction. And that had to do with a stop work order on that property. Now that order is dated, I wrote the 23rd of September, it was actually the 24th. Orders.
The defendants, their officers, agents, service employees, assigns, and successors are permanently enjoined from performing any further work on the interior, exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by the plaintiff's building code officials and stop work orders that have been issued and posted. Occupying the building, you're enjoined from occupying it or allowing anyone else to occupy it unless written authorization is obtained by the building code officials. That's commonly known as occupancy permit. C, if an occupancy permit is granted for the building, using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and pregnant women as a place to give birth for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. So if your daughter or daughter-in-law live there and they have a baby there, that's within their rights. All right, so right now there's a stop work order until it's approved by the zoning officer. And the township would grant permission to turn it into a residence because that's what it's zoned for. So that's the order that was in effect from September 24th. So you filed some motions immediately before that one that I didn't have time to address. So I set those for today. You bench filed on October 24th. Excuse me,
Actually,
September 24th. I'm not sure what this is called. Defendants respectfully move the court to dismiss the above captioned action for lack of jurisdiction, due process violations, and the township's failure to present a lawful case. This action is built entirely on defective proceedings where no proper sworn witnesses testified, no valid authority was demonstrated, and the attorney for the township improperly acted both as advocate and de facto witness. Again, a default entered. There was a temporary injunction that was then granted in full on September 24th. This is bench filed on September 24th, like 1 minute before the hearing. I didn't have time to address it. It's not signed. It isn't titled, but I guess I'll entitle as a motion to dismiss. Mr. Thornton filed an answer to that a few days later, objecting, arguing the motion is not signed. The motion does not need to meet the filing standards set forth in MCR 1.109D. The legal brief was not filed with the motion as required by law. And the defendants have not moved to set aside the default judgment entered in this matter. They simply asked me to dismiss it. While the motion appears to claim that the court lacked personal jurisdiction over the defendants and subject matter jurisdiction, the motion fails to set forth any facts or recognize legal argument to support a claim of lack of jurisdiction. Instead, the motion attempts to raise defenses to the township's claims set forth in his complaint that the defendants could have raised had they filed an answer and participated in deciding the merits of the township's claims. That happened in both cases. You got sued, the lawsuit was served on you, and you never filed a timely answer. So in each case, you got defaulted. And in each case, you didn't file a timely motion properly to set aside the default, where you have to state legitimate reason for not responding to the summons and complaint and file an affidavit of meritorious defense. On all of those matters, you could have been helped by an attorney that knew what they were doing. So Mr. Thornton asked me to strike the motion in its entirety due to the fact that it's unsigned, strike the motion entirety due to failure to comply with the court rules governing the motion, and deny the motion in its entirety.
Your Honor,
Yes,
which one are you talking about that we didn't sign?
this one, bench filed on September 24th. Let's see if it has a date on it.
I don't believe it does, Your Honor. It was undated and unsigned.
So I'm gonna strike that one. Plaintiff's request to strike that unsigned motion is granted. Mr. Thornton, I'll ask you to do that order too. Then this morning at 10:30, I got your newest pleadings. They were filed yesterday afternoon at some point. They're date stamped October 14th. And again, I had to go seek them out. It's titled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Now, there's also a brief in support of the motion to recognize compliance, set aside default, and equitable relief. This has to do with the adjacent house, which would make a very fine house, I guess, if we could turn it into a residential property. You're not the first person to be frustrated by dealing with zoning officials. Some are more strict than others. Some township zoning rules are stricter than others. And they're all stuck with the proper building, electrical, plumbing, mechanical codes that require things be done in a certain way. Those zoning officials are not elected officials. They don't swear an oath. They're hired as an independent contractor by the township to handle the zoning and construction code matters. So again, I didn't see this until this morning. I was busy with other stuff. I shut my door at 10:30 and tried to make sure I could digest all this. So I worked through the lunch. So it's your motion. Either Mr. or Mrs. Yoder, what do you want me to know about your motion and brief to recognize compliance, set aside default, and equitable relief? The one that was filed yesterday.
Oh, can we get the injunction or whatever lifted and get the building permit so we can, maybe I can at least live in a mansion if I can't use it for anything else?
I'd like.
I mean, it's already zoned residential.
Yes, I'd like that.
Well, I applied for a building permit already like the 6th. And according to Lance, Safefield is trying to work with us. Something about the permit, but they've never called me and never sent me any letters or anything. I called twice and nobody answered. But they're trying to work with me to get more information.
All right. Mr. Thornton, apparently what they're really seeking is to figure out how to bring this building into compliance.
There's absolutely nothing that needs to be done, in my opinion, to the default judgment and permanent injunction in this case,
because as we went through a few minutes ago, it lays out what needs to be done. And the Yoders have taken the very first step to do that. I have confirmed with Safe Built that the Yoders did get an application for a building permit and recently filled it out, as Mr. Yoder says, I believe. Not sure if it was October 6th, but it was very recent in the last few days, a week here. And that was filed with Safe Built. And the fee paid. But they have not obtained a building permit. It's my understanding from my discussions with Safe Built that the Yoders need to modify the plans, which were for a birthing center, to show that they're for a residential structure in order to get the building permit issued. So that's where my comments that, and I've directed Safe Built to work with the Yoders, but I highly doubt they've had time to, if there are letters that have been sent, which I don't know if they have been or not, they may not have been received yet, but I know there's an issue with the building plans that need to be revised or added to, supplemented in order for that building permit to be issued. Once that is issued, then they'll have inspections. And if the inspections pass and it's approved, I would assume there'll be a certificate of occupancy granted for it to be used as a residence. And
It would make a very fine house. You call it a mansion, I don't know about that, but it looks like a very nice home. Now, homes get built all day, everywhere here in St. Joe County. As tedious as our building and zoning codes are, could be worse. I read this week, it takes about 7 years to get permitted to build a home or a building in California. So they stop building anything because they can't comply with all the code restrictions. So they don't have enough houses for the people that want to live there. So people become homeless and the prices go up to unaffordable rates. We don't want that. In the gubernatorial campaign, both candidates argued that they wanted to reduce restrictions and red tape so people can get things done commercially. Heaven forbid, if you're trying to do some commercial construction, can be very cumbersome to meet all the code requirements. But all day, every day, somebody's building a house here in St. Joe County. And many are Amish built houses, both in Colin Township and all over the place. They're some of the finest carpenters around. So they know how to do it. And they know how to do it to get it permitted. I don't know who drew your plan. It doesn't look like somebody just showed up and said, hey, look, let's put this building up. It looks like it had some sort of coherent plan. And are there all the other issues that go with it? Plumbing, electrical, mechanical. I don't know if this township has radon abatement or other things that often go into construction, but somebody drew a plan. And somebody needs to redraw it to make this into a residence.
Your Honor,
Yes?
I don't see any necessity of redrawing it because this plan, I drew up the plan to make it suitable for my likings. And that is exactly how I want my house. I wouldn't change a wall. It is exactly what I want for me and my family.
All right. I don't know what the plan looks like.
It's my dream home.
Okay, then we need to get on the same page. And let's say it's a weird central kitchen area with 9 bedrooms off to the sides. If that's your dream home, I don't know. I don't know what it looks like on the inside. So at this point, you and Safe Built haven't really got down to the nitty gritty. So you're saying you would live in this as a residence just as it's designed now? Is that yes?
Yes.
Well, the same thing. I'm gonna deny the motion to set aside the default. These defenses, I guess, could have been raised earlier. The equitable relief you want is just to be able to use this building for your purposes. And I don't have any objection to that. I don't know that I need to grant an order granting you equitable relief. The problem is I'm probably gonna have to continue to hear this, to shepherd this project through. I would be delighted if Safe Built came out and said you could do this, this, and this. These are the electrical requirements, these are the plumbing requirements. The inspectors came out, approved it, and it was built. You could live in it, have your grandkids stay there, but it would be a residence. So I don't deny your motion for equitable relief, but I don't grant it either. Meaning, if you are meeting with Safe Built and you don't feel that they are giving you what you feel is fair and equitable, you can ask me to hear it. In the context of this case, you can file a request for relief. But my hope is that you got builders that know what they're doing. You got plumbers that know what they're doing. You got electricians that know what they're doing. That we can get this built. Winter's coming. It has a tight roof on it, but it needs to get sealed up. So, Mr. Thornton, are you represent that Safe Build is ready and willing to meet with the Yoders to try to make this into a residential property?
Sure. My understanding, Your Honor, is that the plans have to meet the building code for a residence. And that's what's holding up the process. Mr. Yoder, when he went up and filed the application, and I'm getting this secondhand, was very rude and not to the Safe Built personnel and wasn't interested in sticking around. He just filed it and left. So
well,
they're gonna, and I've instructed Safe Built to work with the Yoders and to communicate with the Yoders as to what they.
Sir.
Well, you object that he asked Safe Built to agree to work with you?
I walked in there, I had the application and the check, and she looked at it, and I said, I don't remember exactly what it said, something about a building permit application, and she looked at it and she said something about the check ain't got nothing to do with this or whatever, but she can just hold it with the permit until it gets approved or whatever. I said, no, I'll just take the check with me. And I left. I guess I don't understand what this rude crap is
all right,
about.
you're gonna have to talk to each other.
If you wanna know what rude was, you should have heard the electrical inspector the first time he was out at our place.
Well, everybody is going to have to.
I object to that one.
All right, well, you can object, but you're gonna have to, you don't speak the same language. I don't speak electrical. I don't speak plumbing. I barely speak English, and sometimes I speak legal. They've got certain, now, I don't know what this plan is. I don't know if it has 12 bedrooms and 1,800 square feet. You can't do something like that. And if it has 9 bedrooms and 1 bathroom, you can't do something like that. So they've got certain requirements. from the state of Michigan regarding building codes on what needs to be done. So you need to try to do this within the confines of the Michigan building codes. And they need to work with you to try to get to that point. Yes, sir?
Right, so they had issued a building permit to start with as
Yes.
a resident, so as a residential house, so
Yes.
that floor plan is approved for a residential house.
That's an interesting point. They had at one point issued a building permit on that plan. What's your response to that?
Your Honor, my understanding of that is that the structure is over 3,500 square feet. And and requires under the building code, when it's over 3,500 square feet, that the plans be drawn by an architect because of the size of the structure.
Oh, boy.
And approved by an architect. That's in the Michigan Building Code. So my understanding is Safe Built incorrectly initially approved those plans and then went back and asked for, pursuant to the code, architecturally approved plans. Those, after a very long delay, the Yoders did submit architecturally approved plans that were never approved because those architecturally approved plans did not meet certain code requirements, and a letter was sent, but nothing's ever been followed up with to correct what needs to be corrected in those plans.
Well, they need to do it, and there needs to be some accord, some flexibility to try to get here. Yes, sir?
Yeah, I like how he worded that. After a long period of time, we finally submitted our plans. Well, if you know anything about an architect,
yes,
you contact the guy about getting a building drawn up, you're gonna wait your turn.
Well, I've been there.
All right,
I'm
so
there
that's
now.
exactly what I waited on. Now, if you want to turn that table backwards, we submitted those architectural drawings in October.
Of 24.
Yes. No, 23. Supposedly, I mean, like the dummy I am, I had my architectural drawings in there, so I wait on the officer to let me know what's going to go on with it. From October till March. Finally, in March, I get a phone call that I owe them $2,833, I think it was, to have this drawing approved. That's the first I ever heard anything. The day that that check was cashed, the print was denied.
Same day.
Same day.
And
And
That's
that's
sort of a waste of $2,800 and some
I
dollars.
think it's gonna get you to where you need to go. So nothing has happened on this since.
No, I
March?
dropped that part because it was red tagged and you couldn't work with Safe Built, you couldn't work with plants. He's gonna stop everything. So,
Well, we need a different mindset. We need a mindset. No wonder you're frustrated.
Yeah.
Um,
There's one thing I would like to ask for.
Yes.
We just want to, no more questions, no more answering any questions. We want to reopen this case and.
I'm not sure I understood that.
We just want to just be able to reopen the case and we're getting help.
All right, reopen the case to run a birthing center there?
no,
Reopen the case to build a house?
yeah,
Well, it's never exactly been cold. All right,
no,
you can't run a birthing center in this structure
no.
on that lot. You can turn it into a residential dwelling. And
The reason I'm just saying this is because there's never any ending meeting like with Safe Built in the township, because just like when they said that we need to get an architectural drawing. Okay, my point was if they missed that and they didn't make sure that we have an architecture drawing at the beginning, when we filled out
Yes.
applications, they should have seen to that.
Yeah.
Square footage
Before.
is on every permit we've
Well,
got.
apparently they
Before
issued the
we got-
original permit in error.
So,
So, all right, so you went out and got an architectural drawing.
but that wasn't easy because an architectural drawing, architect wants to make a drawing before the building's there. That was tough, finding someone that's going to do it, and every one of them, they're like, this is the dumbest thing they've ever heard. Trying to draw up an architectural drawing with a building that's standing there. So
The
that was a
architect
big
looked at
problem.
our drawings and said, he sees no problem with them drawing. That's better than most contractors do.
And if you get an architect to make up a drawing, that is undeniable, and they denied it. A licensed
All right,
architectural
well, did
drawing.
they say why they denied it?
There's a list this long.
Okay, well, we have to work on that list.
And that's stupidity.
Well, I don't know what it is, and I'm not ruling at night now, but yeah, it's the horse got behind the cart and is trying to push it. The house got built before the drawing got done. They gave you permission to
I
build
would
it.
have never
and-
built it if they wouldn't have given me a permit.
All right, I accept that. So now we're in a mess. You don't want to let it just molder away. You want to turn it into a house.
True, that's what. was
All
supposed
right,
to be
you
to
may
start
have
with.
some sort of a claim for reliance based on the township's granting the original permit. Again, you could benefit from having a real lawyer that does zoning enforcement stuff. But I'm just trying to get this case to the finish line where they can accept it, you can accept it, you can live in it. You can operate your birthing center in a different jurisdiction. Cullen Township can go on to their other affairs. So can you. So I've denied your motion to set aside the default. I did not grant or deny your motion for equitable relief. I hate to say this, but it's what the answer is. You and Safe Bill need to work together to get to a solution to this problem. I don't know why it took them from October to March to look at your plan, but so there is a drawing. They've got some issues with it. It's been dropped since that point. You need to go back and try to address those issues. Mrs. Yoder?
And another thing that had been mentioned in the last hearing, also about inspection, about only the footer. So I guess we can argue that point too, because the electrical inspection was all totally, everything was fine except one spot that there was one thing that we had to change. And well, that hasn't been changed. I don't think that has been changed
No, you
yet.
can't change it because he said we gotta put something in that does not even get made anymore. And if I would make it with the one that it's there, it would be illegal. Now, I guess you explain that one.
And the electrical guy, he argued the point for 45 minutes that they, that he just, I say argued, he stood there and listened to him for like 45 minutes to being using bad language and putting down his work. But there was no there was no other inspections done.
The electrical inspector and my boy were on the phone for over a half hour. And the inspector was cussing, dropping the F-bomb and everything. And my boy, he's lucky I wasn't on the phone because I would have lost it.
Yeah.
Finally, he calmed down enough to figure out exactly what he wanted. And actually what he wanted was actually right above his head. If you would have just looked, it was right there.
All right.
May I make a comment and maybe a
Yes, I mean,
suggestion?
all this stuff is stuff I can't resolve here. Nobody's under oath. They're just expressing their frustrations. And as I said, they aren't the first person to express frustration with the building code enforcement officials. But what would you like me to know?
Well, first a comment. And I feel I had to put this on the record because, and it's been raised in other pleadings in the case. The Oders are not innocent people here.
they misrepresented what they were going to build to the township in the zoning application. These are all established facts in this case. They misrepresented what they were going to build. They represented it was going to be, first it was a single family home, then it was a 2-family home. It was never represented to be a birthing center. And when it became obvious it was going to be a birthing center, then everything shut down and the building permit, stop work orders were posted, and then they continued on building as a birthing center until this court entered the default judgment, the permanent injunction. They have no choice. Now they're going to go back to use it as a residence. That's fine. That's allowed under the zoning ordinance as a suggestion, but they're not innocent people here in this process. And my suggestion is, and I will instruct Safeville, we'll set up a meeting where Safeville building official will go out and meet on site. But in order to do that, I don't know if all the no trespass signs that are that long and posted by the road, the threats of the intimidation and threats to anybody that goes out there, including Bruce Morris that has to serve documents on the odors. He gets threatened when he goes out there. And so that has to stop. And if that does stop and the no trespassing sign come down, I'll recommend that Safeville go out there, meet with them, and let's figure out what needs to be done to get the building permit issued for the residents.
Well, I agree with that 100%.
I'll comment on
All right,
that
well,
one
just
if
a
I can.
minute. You and Safeville need to meet to figure out what needs to be
Yeah, we
done to
will.
get your permit.
But he said we misrepresented the whole thing to start with. Listen, I had 2 acres of woods behind my barn. All right. My wife told me what she got. She said they need more room. So she called Joe. I said, I'm not cutting any of my trees until I know that building can be built there. So she called Joe from Safeville, told him what we want to do. And he says, build it as a 2-family house. The contractor that drew the building permit made the mistake and put a 1-family resident instead of a 2-family house. That's why there's a 1-family house on there.
That was just one, he came to us and he said that I'm sorry, but I made a mistake. He found his mistake. He said that one of the applications I put down as a 1-family house. And I said, well, we're not holding it against him. I mean, we can make mistakes. We put a wall in the wrong spot, move it, put it
So
where it belongs.
you want it as a 2-family residence?
We wanted to start with
That's
having it
what
as a
Joe told us.
2-family house.
All right, well, I'm not sure what you want now, but there should be a way to do it. There should be a way for you and Safeville to meet, and Safeville will say, all right, this is this, we need to change this, or this is fine, and come up with enough of an accord that you can get a building permit, build it, and get an occupancy permit.
The reason for him to say for a 2-family house, the reason that came in is because of what I'm doing. I wanted more space for myself. And so I wanted to design, I have space for myself, but also have space for my moms. And so I told him what we're doing, and I need more space for both ways. That's why we're going with a bigger building, a new building. And he said, well, you would on the most average have 1 family there with, or 1 mom with you. So call it a 2-family house.
All right,
That's
so
why I was
right
put
off
down
the
for
bat,
2.
you told them this was gonna be an
Exactly.
extension of your birthing
I
center.
wanted a house. I don't want a hospital. It's not medical. It's absolutely nothing to do with medical. I want a house of people want a home birth, a home atmosphere. So that is where we have it as a 2-family house. My belongings, my things, my space, and a space for them.
All right, well, you can't do that, at least not here.
Well,
You
we
can-
realize that part
All right,
now,
okay.
but like the thing, the
All
part
right.
what we're trying to explain is, he's saying that we misrepresented the whole thing. Well, I said, I'm not cutting any trees
All right,
until
I
I
got, yeah,
have
and I got
all my
what she said
permits.
too. She's, so some of that, it doesn't matter what happened in the past, because we're all stuck with it.
Well, he said we
All right, well,
misrepresented
so
it.
your position is we were upfront about it. I don't know. But Judge Stutzman ordered, then I ordered in the permanent injunction that you can't do it. So you want to turn it into a residence. You can do that. So let's figure out how to do it.
Exactly.
All right, you have to allow safe build onto the property. To meet with you and your builder to say, all right, here's what we need to do. The outside is done substantially. The inside needs to get done. So that's just what needs to happen. You, your builder, and Safe Built need to meet on the site, not for fear of trespassing or execution or whatever. They can come to your property, meet with you and your builder and say, all right, let's do this, this, and this. You can't do this, you can't do this. Come up with a plan you can both accept and turn it into a residence. Saying it is
It is a
easier than
residence.
doing it. But to recap, again, Mr. Thorne, if you would do a motion denying the motion to set aside the default. I have not made a ruling on the request for equitable relief. I guess I would have put in the order. The Yoders are directed to facilitate and allow meeting the Safe Built on the property to try to come up with an acceptable building plan.
We can invite them.
Yes. And I would, who's your builder?
I'm the builder.
All right,
So the only thing I've got though is, I don't care if Safe Built wants to come out and inspect. But sitting on the road, taking videos, sitting on the road, spying, that's, no.
well,
We've
I
had that
guess at
numerous
this
times.
point,
I've
there's,
had that happen. I've seen it happen. He was seen videoing my wife.
well, I don't even know what to say. Again, I can't change anything that's already happened. I would like to bring closure to this. I'd like you to find a place where you can continue your birthing, what you call ministry, where it's accepted. More power to you. I'd like you to be able to utilize this property as a dwelling, and everybody can go on with other matters. Yes,
So, Your Honor, before you close the case, so how does this work? Can you explain it to me? How does this work? So we get a lawyer and we,
well, at this point, well, I'm not recommending that you go out and hire a lawyer right now. I would have recommended you hired one at the start. The ship is almost in the harbor. The birthing center has been enjoined. The birthing center has been enjoined from the adjacent property. Now we're simply trying to turn that adjacent property into a dwelling with a acceptable building permit and ultimately an occupancy permit. I don't think you need a lawyer for that. However, if you get into the process and you feel you're being unfairly treated by Safe Built, at that point, you could use the benefits of an attorney who does this sort of thing. There's 16 townships and 8 municipalities in St. Joe County. That adds up to 24. And I'm the judge for all 24 of them. And so I get things from Sherman Township and Fabius Township and Lockport Township and Mendon Township and City of Three Rivers, City of Sturgis, and the rules aren't all exactly the same. What is substantially the same is the Michigan Building Code, which is based on a national building code. Um, So I would first suggest you try to meet with Safe Built and see if you can come to an agreement. If you feel that their requirements are unfair or unmanageable or not legal, at that point, you may consider talking to an attorney. But at this point, all the rulings have been made. You're complying with them. And I'd like to get this building finished. So Mr. Yoder is going to do several orders. Remember, you owe $2,449.34, not twice, just once. I didn't order any fine, and I didn't order anything in the 533 case. I simply ordered that those costs be paid in the 25040 CZ case. Now, Mr. Thornton's going to supply me with the proposed orders that I ordered here today. And when I get them, I will sign them. You can look at those. If you have any challenges, you can do it. All right. Now, your request for equitable relief has not been granted or denied. So if you meet with Safe Built and they won't let you do what you want to do, and you don't feel it's fair, you can ask for relief in the 533 case. You could benefit from an attorney, but I can't compel you to hire an attorney. I don't like when people are practicing law without a license. I think you got taken advantage of. I think you're in a much worse position than you would have been had you had real representation in this matter. I think we would have come to the same conclusion. I don't think you can operate a birthing center there. I don't think you can make a birthing center in the adjacent structure. So I think that would have happened regardless, but I still think you'd have been in a better position. All right, we'll be in recess. Yes?
So as far as finishing the building, it's classed already as finished.
Say that again.
I said, you said that now as far as finishing the building, it was already last hearing, it was already classed finished.
Well, it looks to be finished on the outside. What do you want to get as an occupancy permit?
He stated it's a finished building.
Because it was asked, is that building?
The building is not finished. You can't use it for your intended purpose.
He said,
He who?
Joe, or
Well, no,
Lance,
it's Lance Bonneville had said that the
the building is finished.
I don't recall.
I don't recall that either.
Testifying that the building was finished and been determined to be in compliance with the, there's been no inspection.
No,
Couldn't.
it's not that it's up to date with Safe Built, but from his inspection, he classed that building finished.
All right.
I guess it
Well,
is not.
if they'll give you an occupancy permit, you need to get the building from, it isn't finished.
It is not. There's no trim on there. The
Yeah.
kitchen ain't done, the bathrooms ain't done. there
Yeah,
ain't no
so it's
toilet
not
set.
finished. So it needs to, I don't know what he said. I don't remember
Yeah,
him
he
saying
said
that.
right
but-
there.
He said right there,
Well,
he said
but it
the-
isn't finished.
He said the building's complete and it has no kitchen and there's the most gorgeous kitchen in there.
All right. Well, I'm sure it'll be very nice. It looks nice from the outside. I want you to finish it. I want you to get a building permit. I want you to comply with what they request. I want you to get an occupancy permit and live in it. All right, we'll be in recess.
Guarantee yourself.
Complete, correct?
Yes.
Yeah.